On our jump drive here, make sure we open the right exhibit. There's two on there. Yeah, so the first one. The first one. Okay, two. Number two is wrong. Not deleted? Yeah, delete it. Delete it offline just in case.
I'll tell Clinton too, because Clinton made sure he's gonna. He did better because he did before. There. So delete two. Where's Vicky now?
Oh, right here.
I'm not sure if there's gonna be any more. No. I'll sit back, sit back.
Until it's time to change.
Yeah. What's that one? Just.
When I was out there, I did see one juror coming in, so I don't know if that's the last one we're waiting on. What's Nathan? Okay. They want my desk?
No.
No.
All right, looks like we have a light on, so why don't we have your witness come up to the stand? We'll bring him in.
Oh, he's not. You saw it for a minute, you were. Yeah.
Oh, right, the jurors.
Yeah.
Okay.
Oh, Judge, try this down for you, Anna.
Thank you, Deputy Scott. Welcome back, members of the jury. There aren't any concerns that we need to address. State may call its next witness.
State calls investigator Smallwood.
Please, right hand, please. Do you swear affirm testimony to be in court is the truth and nothing to help you? Yes. You may student. Please state the spirit of first and last name to the court.
I'm Sergeant Gary Smallwood, GARY SMALLWOOD.
I'm sorry, I said sorry, I said investigator Smallwood. Are you not investigator anymore?
No, I've been promoted.
Okay. So being a sergeant is a promotion.
Correct.
Okay, all right. Can you just please explain to the jury, how are you employed?
With the City of Atlanta Police Department,
And how long have you been employed with the city of Atlanta?
about 14 years.
And what are your duties currently as a sergeant with the city of Atlanta?
Just to supervise, monitor, and delegate responsibilities as a supervisor of City of Atlanta Police Department.
Okay, of other police officers?
Correct.
Okay, and are you post certified?
Yes.
Okay, and well, let me jump back. to this, in October of 2020, how were you employed?
At that time, I was at the rank of investigator with the City of Atlanta Police Department.
And what were some of your duties as an investigator with the City of Atlanta?
As an investigator, I get assigned cases or current active cases, get called out to the scene and investigate and see what's going on and try to solve the crime.
What types of crimes?
I was with the major crimes unit, so I investigated shootings, aggravated assaults.
Okay. And back in October 26th of 2020, did you happen to respond to a 878 Norwood Road?
That's correct.
Okay. And why did you respond there?
I respond there because dispatch officers for a person shot at that location.
Okay. So when you got to 878 Norwood, what type of location was that?
It's kind of like a convenience store or a little small plaza.
Okay. And did you speak to anybody at that particular location?
Yes.
Okay. Who did you speak to at that location?
I spoke to Jamon Johnson.
Okay. At some point in time, did you understand that Jamon Johnson had left that location?
Yes.
Okay. All right. And did you have him come back to that location?
Yes.
Okay. All right. At that time, was Mr. Johnson under arrest?
No.
Okay. And was he suspected of committing a crime at that time?
No.
What did Mr. Johnson tell you in regards to the incident?
That he was sitting in the vehicle, him and his friend, Jacob Ingram, and somebody tried to rob them, and he had to defend himself. The suspect had a gun and pointed it in the car, so he ultimately ended up firing his weapon in defense.
Okay. And did he fire that weapon inside of the vehicle?
He said it started inside of the vehicle and he kept firing until he felt he was safe.
Okay. Did he ultimately get out of the vehicle?
Yes.
Were you able to review any surveillance cameras from that location?
Yes.
Okay. And were you able to see the incident take place on surveillance?
Yes.
Okay. Were you able to see the events as Mr. Johnson described them?
Yes.
Okay. I'm going to show you what's been marked as State's Exhibit 116. Do you recognize State's Exhibit 116?
Yes.
And what do you recognize it to be?
The victim's vehicle and Mr. Johnson, from how he described him defending himself. It appears that he's shooting.
Okay. And is this a screenshot taken from that body camera? Or it's not body camera, but surveillance camera?
Surveillance camera, yes.
Okay. And is it a fair and accurate depiction of Mr. Johnson shooting his firearm?
Yes.
All right. At this time, state tenders State's Exhibit 116 into evidence.
No objection.
116 is admitted.
Okay. At some point in time, and can we just show 116, please? Thank you. While that's pulling up, at some point in time, were you able to look for, or were you able to see any evidence that would help you in trying to solve this particular case?
Yes.
Okay. What did you see?
Broken glass and shell casings located in the parking lot.
I'm sorry.
Shell casings located in the parking lot.
Okay. And particularly, where were those shell casings that you located? Where were they?
They're on the outside in the parking lot, from where the vehicle possibly was, the victim's vehicle.
Okay. I'm going to show you State's Exhibit 48 through 59. No, I think we need to be made a host to publish.
Which username?
Mr. Wright.
All right, if we could make Mr. Wright a co-host on Zoom.
Do you recognize State's Exhibit 48 through 59? Yeah. 116, yes. Okay. Do you recognize State's Exhibit 48 through 59?
Yes.
Okay. All right. We'll pause right there for a second, but we'll go back. We'll go to State's Exhibit 116. What kind of car did the defendant tell you he was driving?
Gray Acura TL.
Okay. Is that what's depicted here in this particular video or screenshot?
Yes, it appears so.
Okay. And at some point you arrived on the scene. Were you able to locate any shell casings?
At 878 Norwood, correct?
Okay.
Yeah.
All right. Can you just point behind you where you were able to locate some of those shell casings?
Kind of in this area right here.
Okay. All right. Let's go back. Thank you. If we could please, you recognize State's Exhibit 48 through 59, correct?
Yes.
And how do you recognize them?
As being the incident location that I arrived to investigate the crime or the scene.
All right. And are those photographs of that scene?
Yes.
Okay. Are they fair and accurate copies or depictions of that scene as you saw them?
Yeah, yes.
All right. State tenders State's Exhibit 48 through 59 into evidence.
No objection.
48 through 59 are admitted.
I'm going to show you what's been marked as State's Exhibit 84. Now, when you're investigating, do you happen to have help investigating your
Yes.
particular crime?
Yes.
And who are the people that help you investigate?
Other officers and then crime scene technicians have to come out and take photographs and collect evidence.
As a investigator, are you the leader, the director of the crime scene?
Sort of, yeah.
Okay, all right. So you would tell or help or direct people to do certain things or collect specific evidence?
That's correct.
All right. I'm showing you what's been marked as State's Exhibit 84, correct? It's 84, right?
84, yes.
Do you recognize State's Exhibit 84?
Yes.
All right. What is State's Exhibit 84?
It's shell casings that was collected and turned into evidence.
Okay. Is they were packaged in that brown paper bag?
Correct.
All right. State tender State's Exhibit 84 into evidence.
No objection.
Admitted.
All right. So let's go to State's Exhibit 48 through 59, please. Can we publish it? Yes, please. Okay. What are we seeing right here?
That's the location, the incident location.
All right. Can we go to the next slide, please? Is that 878 Norwood?
Correct.
Is that located in Fulton County?
Yes.
Okay. Do you typically work this zone or this area? Or did you typically work this zone or area?
Well, as an investigator, I'm over the whole city.
Okay, all right. Next slide, please. And let me ask you, is this located in Fulton County?
Yes.
Okay. If we could zoom in, please. All right, what do we have here in State's Exhibit 50?
Just yellow markers showing where the possible shell casings were located.
Okay. And when those markers, they track with each of the projectiles found in Exhibit 84?
Yes.
Okay, all right. All right, next slide, please. Actually, can we stay on this? And where was the car? I know we have the screenshot in number 116, but where was that car located? If you
It appears from the incident, the car was
Okay.
located somewhere in that vicinity.
Okay, all right. If we can go to the next slide, please. Now, exhibits, this exhibit number 51 and the rest of the exhibits are all shell casings like this, correct?
Yes.
Okay. And And they just show a shell casing and where they were found and the marker number. Is that right?
Yes.
All right. No more. Okay. When speaking to Jamon Johnson, what did he say what he did with that firearm?
He said as they were leaving the incident location, he threw the Glock 9mm out the window.
Okay. But he told you it was a Glock 9mm.
Yes.
All right. Was there a time period between the time that you or officers first encountered Mr. Johnson and this particular incident?
Correct.
Okay. All right. And you said that he went into a home on Thomasville Road. Is that right?
Yeah, he went to the address 1759 Thomasville Drive.
I know at some point in time, can you describe your efforts in searching for this weapon?
The officers requested K9 to come out there and kind of canvass the area, see if he can do an article search and locate the weapon, but they were unsuccessful.
Okay. All right. At any point, did anybody go inside of that Thomasville Road house and search that house for that weapon?
No, I don't believe so.
All right. I think that's all. No further questions. Thank you.
Cross-examination.
Morning, Sergeant Smallwood.
Good morning.
So, Mr. Johnson, you said that he referred to the weapon as his weapon. Did he actually say it was his weapon or someone else's weapon?
I don't recall that.
Okay, all right. And he said he told you that he threw the Glock 9mm out of the window. Did he say where where he was when he threw it out the window?
There's like a bridge, like a street, like a bridge, and he said he just threw it out the window. And then that's where we searched the area where he pointed to where he possibly threw the gun out.
Yes, sir. So, and you said it was 9mm Glock. So, were all the shell casings that were located 9mm?
I believe so. I don't see in the report that it shows any other type of caliber.
How many shell cases is in that package?
It's 9.
Okay. And does the package indicate that all those shell casings are 9mm?
Yes.
Okay. Thank you.
Can you redirect?
You spoke to Mr. Johnson. You saw him that evening.
Yes.
Do you see Mr. Johnson in the courtroom today?
Yes.
All right. And can you please point him out by an article of clothing he's wearing?
He's to the left of me at the desk wearing black with the black male with the dreads.
All right. Let the record reflect that this witness has identified the defendant. Thank you.
The record will so reflect. Can this witness be excused, Ms. Russell?
Yes, Your Honor.
Mr. Brown?
Yes, Your Honor.
All right. Thank you. You can leave the exhibits there. We'll take care of them. All right. State may call its next witness.
Mark Tanner.
Okay.
I do.
Please state your first and last name for the court.
Good morning. My name is Mark Tanner, MarkTanner.
Good morning, Mr. Tanner. How
Good
are you?
morning.
Please introduce yourself, or let me ask you this. What is your occupation right now?
I'm currently a firearms and tool marks examiner at the Bureau of Alcohol, Tobacco, Firearms, and Explosives, also known as the ATF in Huntsville, Alabama.
Okay. And what currently are your duties?
So currently, my duties involve working on the NIBIN system, which is the National Integrated Ballistics Information Network, where we service the entire nation, linking gun crimes and gun shooting incidences across the nation. And I'm the firearms and tool marks examiner on site for the second shift over in Huntsville.
How long have you been a firearm and tool mark examiner?
It's 8.5 years.
Okay. Prior to that, what did you do?
Prior to ATF or prior to firearms and tool marks?
Excuse me, ATF.
Prior to ATF, I worked at the Georgia Bureau of Investigation here in Atlanta as a firearms and tool marks examiner. And I started there in 2016 and worked until a year ago.
So can you explain what type of training you have to do to become a firearm and tool mark examiner?
Yes, so the requirements for the GBI is to hold a physical science degree. So I have a bachelor's of science in chemistry from Armstrong State University down in Savannah. I then I got hired on at the GBI and began a 2-year training program. This consisted of learning ammunition components, firearms operation and safety, and then microscopic comparison of bullets and cartridge cases. I did then serial number restoration on firearms, distance determination of shooter to clothing, and then I did tool mark analysis on like wire snips and bolt cutters and such. That first 13 months ended, and then I began a 7-month period where I would work normal casework under the direct supervision of a fully trained examiner called the supervised casework. I would, cases from agencies such as Fulton County would come into the door and I would work them, hand them off to a second trained examiner, and they would completely rework it. At the completion of that 7 months, I began my verification and peer review training. So verification is where a second examiner will fully rework a case on the comparison aspect and then render their own conclusions and compare it to the primary analysts. Then the peer reviewer will go through all the documentation, ensuring everything was done properly per GBI policy. After that long 2 years, I became an independent examiner where I worked in that position until I left for the ATF.
How many times have you compared shell casings and projectiles, or in total?
So at the GBI, I did about 750 to 800 cases, and that ranged in one cartridge case up to anywhere around 50 cartridge cases, depending on the situation. Since I got to the ATF, I've done thousands.
Okay. Have you ever testified as an expert witness before?
I have.
How many times?
89.
So this would be number 90 if you are tendered as an expert.
If tendered, this would be 90.
Okay. In what counties have you testified as an expert?
Multiple counties throughout Georgia, all of them being in Georgia.
All right. And what fields were you tendered as an expert in?
Firearms examination.
All right. Your Honor, at this time, state tenders Mr. Mark Tanner as an expert in firearm examination.
No objection, Your Honor.
State may proceed.
Okay. Briefly, because I know this can be long, but can you just explain to the jury how a firearm works?
So a firearm has a trigger mechanism that connects in some way to a firing pin. When the trigger is pulled, the firing pin strikes the cartridge or the unfired ammunition. It'll strike the primer on it. That primer creates a spark, ignites the gunpowder. The cartridge will combust, and it will send the projectile downrange. Depending on the firearm, the cartridge case will stay in the firearm or it will be ejected from the firearm.
And specifically that cartridge case, if it is ejected from a firearm, what type of firearms are those?
So those would be what I would call a pistol. So handgun has two different types of firearms. It has a revolver and a pistol. So the revolver has the central axis and the cartridge cases will stay in. What she asked about the ones that eject, we call pistols. They have the slide on the top that'll move rearward and forward, and the cartridge case will be extracted from the chamber and ejected from the firearm.
Okay. Let me ask you this, as an expert in your field, when cartridge cases are ejected, where do they usually go?
Generally, for most firearms, it's going to be right in rear of the firearm.
Right in rear of the firearm?
Correct.
Okay. So if a person is standing one way, it just depends on where they're pointing the firearm at.
It depends on how the firearm's being held and in which direction it's being pointed.
Okay, all right. Let me direct your attention to the GBI case number 2021-1000-207. Do you know if you conducted any testing in that particular GBI case number?
I did.
Okay. What testing, if any, did you perform?
So I did basic firearms analysis. So I compared bullets and cartridge cases to firearms submitted and then to the evidence itself.
Okay. Did you do any, and did you memorialize your findings in a report?
I did.
Okay. I'm showing you what's been marked as State's Exhibit 64.
Okay.
Do you recognize State's Exhibit 64?
I do.
And how do you recognize this?
So there's the GBI case number or DOF's case number at the top right of the case. And then on the third page is my signature with my title.
And is this report a fair and accurate copy of the report that you created?
It appeared so, yes.
Okay. At this time, State tenders State's Exhibit 64 into evidence.
No objection.
64 is admitted.
All right. All right. Can we publish, Your Honor?
You may.
Okay. So this is a 3-page report. It's pretty long, or it's actually 2 pages, excuse me. It's a pretty long report for your standards, or usually what you create, correct?
Yes, this is a more on the lengthier side for reports.
Okay. All right. So if we could first just talk about where it says case individuals, what does that particularly mean to you?
Case individuals is simply the names placed on the submission form by the submitting agencies. And we just put it there for documentation purposes.
Okay. Under that, we see something saying evidence. Can you describe or explain to the jury? Can you zoom in, please, a little bit? Thank you. Can you explain to the jury? I see, looks like 3 different groupings here. What those 3 different groupings are?
Okay, so when looking at this evidence section, you have a date at which the evidence was submitted and which agency submitted it. For court clarification here, in that first line, it says evidence from Fulton County District Attorney J. Rickman. The J. Rickman was a bug at the GBI's facility that we were trying to problem solve at the time this case was in the system. So they're unsure of how that name even got on the report. I'm just being completely honest with you guys. So it has J. Rickman has no relevance to that situation. Okay, it was just simply a computer bug. Okay, so you have the date and the agency that submitted it in each of the separate little sections. And then on the left side, you're gonna see the GBI case number followed by a dash with the GBI item number. So for instance, the first one, 2021-1000207, that's the case number. And then -005 would be the GBI item number. So you have that first section submitted by one agency, the second section submitted by a second agency, and then the third section is actually a second case submitted by Fulton County DA's office. That's just how GBI lays out the reports for the evidence section.
Through through the process that you examine all of these items, were you able to determine at all which case numbers, and it looks like 1000207 and 1033844, were you able to determine, or do you know anything about those case numbers?
I do.
Okay. Do you mind just explain that to the jury?
So based on the submission forms for these cases, the 1000207 was a murder that occurred and evidence collected at that murder scene. And then the second case number, 2021-1033844, was a second incident that occurred prior. And from my understanding, it was an attempted robbery.
All right. So essentially and it looks like the district attorney's office, my office, asked you to compare one case to another case. Is that
Correct.
okay. And not only one case to another case, but there may have been other items. And if we go to the top here, not to the top, but item 005, which is a what?
So 005 is a Smith & Wesson 9mm pistol.
Okay. So that was asked to be compared to some of the items not only found on the murder scene, but elsewhere as well?
Yes, it was when we receive evidence at the lab, the agencies just simply request firearms analysis and we compare everything to each other, trying to see if anything links to anything. And
Okay.
so I compared it as best as I could to everything related.
Okay. All right. I want to go to, in that top paragraph, items 006A and 006B.
Okay.
And I'll specifically start with 006B. That 006B, what was that?
So 6B was 9mm cartridge cases. And again, these were found at the murder scene.
And you received all of this, correct?
I did, yes.
Sure. Handing you what were previously tendered as State's Exhibit 120. You recognize State's Exhibit 120?
I do.
And how do you recognize that?
State's Exhibit 120 recognized because it has the GBI case number, it has the item number, the barcode on it, and then underneath the red seal up top is my blue seal with my initials on it.
And what's in that State's Exhibit?
So State's 120 consists of items 6A and 6B.
And pull that out. So you might need some scissors and.
I got it.
Good.
Mhm.
And are those little packets that you're pulling out shell casing?
Yes, these little manila envelopes are the individual cartridge cases listed. They're individually packaged.
Now, does each individual package relate back to, you see APD number 6 through 9, 12 through 14, 16, and 17?
Yes, they would.
So do they relate back?
Yes, so APD has written on these packages the evidence markers numbers that they have listed there on my report, and they're individually written on each one of these, indicating which one was at which location.
And then all those shell casings right there.
Yes,
Okay.
all of these.
I'm gonna show you what's been marked as State's Exhibit 81.
Okay. Okay,
Do you recognize State's Exhibit 81?
I do.
And how do you recognize that?
So States 81 has the GBI case number and the barcode with my seal and initials. And then I also confirm the serial number.
Okay. And does State's Exhibit 81 have a number listed here?
Yes, it would be the GBI item number 5.
Okay.
So 005.
All right. Okay. And you can put those back, but you can also put. Shuffle these out. Thank you. And just so we're clear, this particular paragraph, 1000207, those relate back to the murder scene.
Yes.
I'm gonna hand you what's been marked as already submitted on State Exhibit 122.
Okay.
Do you recognize State Exhibit 122?
Yes, I do.
And how do you recognize State's Exhibit 122?
Again, the GBI case number, the barcode, and then it has my blue seal with my initials on it.
Okay. And according to this, go down, there we go. According to what you, sorry, we're having issues with our screen. According to your report, what were these?
So States 122 is the evidence in that middle paragraph, item 2, 2A through 2F from the Fulton County Medical Examiner's Office.
I'm going to show you what's been marked as State's Exhibit 84. Do you recognize State's Exhibit 84?
I do.
And then can you tell us what State's Exhibit 84 is?
So States 84 is in that third paragraph. It's from the case 33844. It's item number 1, which would include 1A and 1B.
Okay, 1A and 1B.
Correct.
All right. All right, let's go to, all right, if we can go to results and conclusions, please. Okay, let's start with, and I'm gonna bring out a board. And Your Honor, this is going to be State's, 64A is demonstrative.
All right, any objections to publishing 64A, Mr. Brown, or tendering as a demonstrative?
No objection to it being tendered as a demonstrative aid.
All
And I
right,
have a copy for the court reporter as well. A paper copy.
so 64A is admitted.
Okay, all right, so if we can start at results and conclusions, please. If you can go ahead and we can start with results and conclusion.
Okay.
The first paragraph.
Oh, okay. Sorry. Okay, so this is a lot of technical reading I'm about to do. I'll explain everything. Don't worry. Okay. Microscopic examination and comparison reveal that the bullets, items 2D and 2E of Crime Lab case 2021-1000207 were fired from the firearm item 8 of the same Crime Lab case number based on agreement of class and individual characteristics.
And I think you said item 8. Is that an 8 or a 5 there?
Item 5, I apologize.
It's okay. So at some point you were able to test the firearm that was submitted. Is that correct?
Yes. So, yes, I tested it and then made test fires of that firearm.
Okay. And then you ultimately compared that with items that came from the Fulton County Medical Examiner's Office.
Correct. Item 2D and 2E were projectiles submitted by the Fulton County Medical Examiner's Office. I then test fired the firearm, and I used those test fires, compared them microscopically, looking at the characteristics on them to those two projectiles from the medical examiner's office, and determined that they were fired from that firearm.
And according to your notes or even the actual exhibits, items 2D and 2E, which is states exhibit number 122, which of those shell case, or which one of those projectiles, do you know where they came from? 2D and 2E?
Yes, specifically based on what the medical examiner wrote on the packaging, they were indicated as from the left chest and the head.
So I want to go to the second paragraph here under results and conclusions.
Okay.
Okay. Can you read that and explain that to the jury?
Okay. So microscopic examination and comparison of the bullets, items 2A, 2B, and 2C were all fired from the same firearm based on the agreement of class and individual characteristics. Excuse me, I'm sorry. And are consistent with being fired from a Glock 9mm pistol.
All right, so I understand that you actually received 5 little jewelry boxes. I call them jewelry boxes. But one of those jewelry boxes, were you able, I guess the projectile fragment, were you able to test that?
I received 6 jewel box. You're good. No, 6 jewel boxes from the medical examiner's office. That 6th one was too small and there wasn't any characteristics visible on it, so I wasn't able to do any analysis on it.
So everything that you receive from the agencies, you're not always able to test?
Correct. There's some stuff that doesn't have any evidentiary value to us as firearms examiners.
Okay. So you said 2A, 2B, and 2C were fired from a Glock 9mm.
Yes.
If we could go to the third paragraph or it's actually the first paragraph on the second page. Yeah, and you can read that.
Okay. Microscopic examination and comparison revealed that the bullets 2A, 2B, and 2C were not fired in the firearm item 5 based on disagreement of class characteristics.
Okay, So, items 2A, 2B, and 2C, those two items that you said were fired from the same firearm were not fired from this Smith and Wesson.
Correct.
Okay, so the other projectiles that came out of the body from the Fulton Medical Examiner's office were fired from a separate gun than the one that you had.
Correct. Those three, 2A, 2B, and 2C were fired in a separate firearm.
And just so that we're clear, you only had one firearm for testing.
Correct.
Okay. No other firearm was submitted?
No.
All right. If we can go to that second paragraph, please.
Okay. Microscopic examination reveals that the lead fragment, item 2F, was not suitable for comparison. So that sixth box that I received is just a little lead fragment. There were no characteristics. It was unsuitable for comparison. And that's all I did with it.
Okay. Thank you. Sorry, we're trying to pull it back up. Hold on one second. Okay, if we could please go to that third paragraph on the second page.
Okay, so the third paragraph, microscopic examination and comparison revealed that the cartridge cases item 6A was fired from the firearm item 5 based on agreement of class and individual characteristics.
Okay, if we could please go to, can you pull out 6A?
Mhm. Okay.
And what markers, APD markers, come back to item 6A?
So item 6A is two 9mm cartridge cases. The two markers associated with them based on what APD wrote on the packaging was marker 11 and marker 18.
And from your knowledge of doing this and as an expert, do those markers usually relate back to a picture, or do crime scene techs take pictures of that particular shell casing or casing on the scene?
Yes, during my training, we were instructed that when on crime scene pictures are taken of the scenes and of evidence marker numbers.
All right, and if you don't mind, can you just
Absolutely.
just for a second, witness step down, Your Honor? There you go. Okay, so we were just on this paragraph here. Item 5, the firearm that we have over there, the Smith and Wesson.
Correct.
Fired 6A, which are markers 11 and markers 18.
That is correct, yes.
Okay, now let's, just so we're clear on this, 11 and 18 came from the same firearm.
Correct.
Okay, and we may get to it later on, but the other items in 6A, did those come from this firearm?
So 6A would be those two cartridge cases, and then 6B would be 9 other cartridge cases. Those 9 did not come from the Smith and Wesson.
Okay, all right. And then you probably need your notes, but can you tell me 6B, what were the item numbers or the APD markings that came from 6B? Or the shell casings that were 6B?
So APD had listed on the 9 cartridge cases 8 evidence markers numbers 6 through 9. So 6, 7, 8, and 9. 12, 13, and 14, and 16 and 17.
Okay, all right. So these shell casings here, and this one picture doesn't list all of these, right? Am I correct with that? I think it's.
Correct, that would be 8.
Okay, all right, but 17, you said there was a number 16 and 17 as well.
Correct.
Okay, all right. And there could be another picture with 16 and 17, but it's just not on this picture here.
It's possible, yes.
Okay, all right, okay. Can you go to, and I think that's the next paragraph. Can you explain to the jury what this means? or read to the jury what that is and what this.
Okay, microscopic examination and
And you
comparison.
can have a seat. I'm sorry.
In comparison of the cartridge cases, item 6B. Of Crime Lab case 2021-1000207 and items 1A and 3A of Crime Lab case 2021-1033844 reveal they were fired in the same firearm and are consistent with being fired in Glock 9mm pistols.
All right. Okay. Can you please go to, now let me ask you a question about your reports. You earlier stated that you usually compare everything that's given to you.
Correct.
All right. Can you explain, I think this is paragraph 6 that we just talked about, paragraph 7 on, can you explain what are your conclusions and what are they explaining pertaining to the evidence and the attempted robbery?
Okay. So the GBI, whenever we have evidence submitted, we don't separate it when we're doing conclusions, we don't separate it based on the different case numbers specifically. We just group everything together as it fits. But this portion, so after that paragraph I just read, which is the fourth paragraph, which is going to be this paragraph right here. This paragraph, anything after that is talking about the previous incident where there was the attempted robbery. All of that is talking about the evidence from that scene and how it relates to the evidence from the murder scene.
Okay.
So it kind of intercompares itself and then has a little bit to the murder scene.
Okay. However, do you know what case we're here on today for?
Correct.
And what case is that?
It's my understanding we're here for the murder.
Okay. So you have compared some of the items from the attempted robbery, which could include from multiple firearms, correct?
Correct. Yes.
All right. With each other, you can.
Yes.
Okay.
Yes. And that's just the GBI's policy to include everything in one big report.
Okay. Based on the cartridge casings from the murder scene, how many firearms were there?
2.
Okay. All right. And based on the projectiles from the body, how many firearms were there?
2.
Okay. What caliber shell casings came from the Smith & Wesson?
9mm.
Okay. And what caliber shell casings came from the other weapon?
9mm as well.
You mentioned earlier something about a NIBIN program.
Yes.
Okay. Was NIBIN used in this particular case?
It was. Yes.
Okay. Can you tell the jury a little bit about that?
So previously I mentioned NIBIN. So it's housed by the ATF, but local agencies have their own systems where they can upload images of cartridge cases from scenes and from cases. And those images are run across all other images within the system, trying to link crimes and situations to each other. So Atlanta PD, for instance, they have a NIBIN system and they have people trained to go through those images and render potential associations or potential leads saying that, hey, these two cases might be involved with each other. We should further investigate this. And based on looking at the NIBIN system at work at the ATF, I saw that the APD had done that.
Okay. All right. Were you able to further, with your particular testing, able to confirm that NIBIN? Is it called a hit or a NIBIN?
So they're called hits or leads. So it's just saying, hey, these two might be linked. So APD put a cartridge case. Sorry, I won't get into that. I did confirm the hit that APD made with this testing that I just talked about.
Okay. So, cartridge casing from one scene with a cartridge casing from another scene, there could be a hit.
Correct. So there was a cartridge case entered by APD from the murder scene and a cartridge case entered from APD from the attempted robbery scene. They issued a hit or a lead based on those two. And then whenever I did my analysis, that confirmed that NIBIN lead.
And I just want to make sure that a jury understands when we're talking about the remainder of the paragraphs, and we're not going into too much detail, but let's go to paragraph 1. It's the 6th paragraph on here. I'm sorry, not the 6th paragraph. Yep, excuse me, 6th paragraph on here. Here you have can you just explain what that is and how is that not related to, I guess, the murder scene?
So, the 6th paragraph here, it states what I've already described, that item 6B, those 9mm cartridge cases were not fired in the Smith & Wesson. And then it also goes to tell about all of the other evidence from the first scene, that none of it was fired from the Smith & Wesson. That's what that paragraph says. So it's showing that, it's just showing that connection. And it's just, again, the reason I did that was because the GBI required it.
Okay, all right. All right. However, if we go back to the murder scene, how many firearms were there?
Based on the cartridge cases, 2.
Okay, and one set of cartridge casings that you were able to examine came from the Smith & Wesson?
Correct.
And then the other set came from a Glock 9?
Correct.
I don't have any other questions. Thank you.
Ms. Russell, if you could take down your demonstrative.
Oh, yes.
Could leave it up for.
That's perfectly fine.
Thank you.
All right, Mr. Brown.
Morning, Mr. Taylor.
Good morning. How are you, sir?
I'm fine. So cartridge casings were found at the scene of the murder. How many was related to the Smith & Wesson?
2.
And how many from the another weapon?
9.
9, okay. Unless someone saw a particular weapon being fired and saw the cartridge casings being ejected, there's no real way to know how long those cartridge casings was at a particular location. Is that correct?
Correct. Yes. There's no way to determine how long cartridge cases had been in a location or how long between when they were shot versus when they were found.
So, as per your expertise, it's possible that I think you said it was 9 that was from another weapon?
Correct.
It's possible that they could have nothing to do with the murder. Isn't that correct?
Yeah, it's always possible. There's always room for possibility.
No further questions, Your Honor. Thank you.
Any redirect?
The last question counsel asked you was about possibility, right? About those 9 cartridge casings could possibly not be from the murder.
Correct.
Okay. If we go back to let me just ask you this. Do shell casings magically appear out of nowhere?
Objection, that's vague. Magically?
Overruled. I'll allow you to take that up on cross, if you like.
Can they magically appear out of nowhere?
No.
And when there's a body on in your expertise, when there's a body with shell casings, or excuse me, projectiles in it, and those projectiles haven't been fired from a Smith and Wesson pistol, which we have here, and from a Glock 9mm pistol, is it likely that shell casings will appear on the scene?
Objection leading, counsel is testifying.
All right, Ms. Russell?
I don't think I'm leading. I'm asking him a question about his expertise.
All right. I don't think, I'll overrule the objection, Mr. Brown.
Could you ask the question again? I'm sorry.
Yes. When there's a body with shell casings, or excuse me, with projectiles that came from a Smith and Wesson, okay, and body with projectiles that came from a Glock 9mm pistols, is it uncommon that shell casings will be lying around the body?
So they might not be around the body.
Hold on,
I
just a
think-
second.
Objection. I believe this calls for speculation.
So at this point, Ms. Russell, I don't know if this is going to fall within just what he was qualified to testify on in terms of how shell casings can appear at a scene. So maybe you can rephrase that if you'd like to.
Okay. When a Glock 9mm is fired, a pistol, Glock 9mm pistol is fired, what happens to the shell casings?
They are ejected from the firearm.
And when a Smith and Wesson is fired, what happens to those shell casings?
They are ejected from the firearm.
And sometimes they'll explain to what could happen to those shell casings when
So
they're fired.
when a Glock or a Smith and Wesson is fired, the projectile travels down the barrel and onto the target, and the cartridge cases are ejected from the gun, landing somewhere nearby in a vicinity.
Okay, all right, thank you.
You recrossed, Mr. Brown.
No recross, Your Honor.
Ms. Russell, can this witness be excused?
Yes.
Thank you, Mr. Tanner.
Thank you, Your Honor.
All right, unless any of the members of the jury need a longer break. If not, State can call its next witness, but members of the jury, feel free to stand up, take a stretch break, and place if you need one as the next witness makes their way in.
Guess they'll just stretch you.
State may call its next witness.
Yes, Your Honor, the state calls Investigator Scott.
You swear affirm that the testimony you give a court is the truth, and nothing but the truth will help you.
Yes.
You may be seated. Would you please state and spell your first and last name for the court?
My first name is Darline. That's Darline. My last name is Scott, Scott.
Good morning, Investigator Scott. Where are you currently employed?
City of Atlanta,
And how long have you been employed with the City of Atlanta?
28 years.
And what department are you employed with the City of Atlanta?
The fugitive unit,
And what unit were you assigned to back in December of 2020?
the Atlanta fugitive unit.
What are some of your job duties and responsibilities with the Atlanta Fugitive Unit?
My job duty is to, when the City of Atlanta take out outstanding warrants for the wanted fugitive, murder warrants, whatever the warrant is, my job is to locate the wanted fugitive for Atlanta Police Department.
And Investigator Scott, are you post-certified?
Yes, I am.
Were you post-certified back in December of 2020?
Yes, I was.
I want to direct your attention to December 16th of 2020. Did you go to the address of 1229 Kipling Street?
Yes, I did.
And what county is that in?
Fulton County.
What type of location is 1229 Kipling Street?
It's a resident with us a house.
And why did you go to this house?
I had an active warrant for Jamon Johnson. He was wanted for murder, and I also had a search warrant for that location.
And Investigator Scott, can you explain to the jury how you came about getting the search warrant for Jamon Johnson?
On December the 15th of 2020, I went to that location. I was doing surveillance. I saw the wanted fugitive in the backyard. I went and took out a warrant to go in the residence to get him.
And just to clarify, December the 15th, you went to that 1229 Kipling Street address?
Yes.
And you saw Jamon Johnson?
Yes.
Okay. Can you please tell the jury what you did when you went back to that address on December the 16th of 2020?
On December the 16th on 2020, we went back to 1229 Kipling Street. I went back with the team. That's with my fugitive team. The fugitive team went and knocked on the front door of the resident. The fugitive team called out for Mr. Johnson to come outside the house because we know he was inside. A female opened the door and I asked her, was Mr. Johnson inside? She said yes. She also stated that my small child is inside the house. So at that time, we was able to get her and the small child out the house. I took them to my car, set them in my car for the safety, and the team continued to call Mr. Johnson out the house. And at that time, Mr. Johnson was hiding in the attic. They continued to call him. At that time, they heard he said a verbal that he was coming down. So he came out the attic.
And Jamon Johnson came down from the attic?
Yes, ma'am, he did.
After Jamon Johnson came out of the attic from that 1229 Kipling address, what happened next?
After that, he was taken into custody. He was taken down to headquarters, which is 226 Peachtree Street, and he was released to the lead detective, the homicide lead detective.
Investigator Scott, do you see the individual Jamon Johnson who was taken into custody on December the 16th of 2020?
Yes, I do.
And can you identify him by an article of clothing and where he's seated in court?
He's seated on the left-hand side. He's wearing a black suit with a black shirt, and he has dreads in his hair.
Your Honor, let the record reflect that Investigator Scott has identified the defendant.
The record will so reflect.
Thank you. No further questions.
Any cross-examination?
No cross, Your Honor.
Ms. Washington, can this witness be excused?
Yes, Your Honor.
Thank you, investigator.
Thank you.
State may call its next witness.
Your Honor, may we have 1 second, please? Your Honor, at this time, the state would like to read in a stipulation.
And is this marked as an exhibit?
State's Exhibit 121.
Any objection to the admission or publication of State's Exhibit 121?
No objection, Your Honor.
All right, 121 is admitted.
All right, this is a stipulation of the state and the defendant. The state and defendant enter into the following stipulation. Jamon Johnson was convicted of a felony on October 5th, 2012, in indictment number 12 SC 106855 in the Superior Court of Fulton County, and on November 25th, 2020, was still considered a convicted felon. Said prior felony offenses in indictment number 12 SC 106855 involved the possession of a firearm. It was signed this 16th day of July 2024 by me, Danielle Russell, attorney for the defendant, Joe Louis Brown, and Mr. Jamon Johnson, defendant. State's Exhibit 121, Your Honor.
All right, members of the jury, as it relates to Exhibit 121, I do have a specific instruction of the law that I need to give you, which is that you've just received in evidence a prior conviction of the defendant. You may consider this evidence only insofar as it may relate to a required element in the offenses of this indictment and not for any other purpose. Any further evidence, Ms. Russell?
No, Your Honor, the state rests.
All right, members of the jury, there are a few things we have to take up outside of your presence. So I'll ask you to step into the back and we'll let you know when we can be back with you.
All right, for the jury.
All right, just as a matter of housekeeping, I just want to make sure my notes are right, so correct me if I'm wrong. But when it comes to the state's exhibits, I did not make note of a exhibit 47, 79, or 119. Just want to confirm that for the record. 47, 79, and 119.
That's correct.
All right. Okay, the state now having rested, Mr. Brown, any motions on behalf of the defense?
Defendant Jamon Johnson, on his behalf, I move for a directed verdict of not guilty.
Any particular argument or reason underlying a directed verdict in this case?
Yes, there's basically two, the state has two allegations that my client was at the crime scene committing the murder. The video of the shooters, along with some screenshots, and the ballistics, the shell casings, cartridge casings. Mr. Tanner just testified that those cartridge casings could have been there any time before the murder. So they don't place Mr. Johnson at the crime scene. The ballistics do not. The ballistic, actually, there's no evidence placing the shell casings, having it connected with Mr. Johnson at all. As far as the video, we saw the video. The video doesn't show anyone's faces. Whoever was doing the shooting, they were concealing their faces. So the state is asking the jury to compare a screenshot to the shooter's clothing, and I maintain that that is just not enough to prove guilt beyond a reasonable doubt. So based on that, I'm asking for the court to enter a verdict, a directed verdict of not guilty.
Ms. Russell.
Yes, Your Honor. We believe the state has proven this case at this time beyond a reasonable doubt, but I don't know if that's even the standard right now, Your Honor. As for count one murder, Your Honor, we have placed Mr. Johnson at the scene via surveillance video, via the his clothing that he was wearing, and the proximity from the first scene to the second scene. Also, Your Honor, Mr. Johnson himself in his interview stated that he was that first person on that scene. I think that could be left up to the jury to decide whether or not they believe that is Mr. Johnson in the second scene. And I say second scene, I mean on the same day, the same incident. Your Honor, and also the ballistics testing, Your Honor, Mr. Johnson admitted that he fired multiple shots on October 25th, 2020. October 26, 2020. And those shell casings were collected. There was, he admitted that to multiple officers. Those shell casings matched directly with the murder scene from our case, November 25th, 2020. That places Mr. Johnson there.
And remind me, was there any testimony or anything presented about whether the projectiles recovered during the autopsy could also be tested and compared to these shell casings?
Your Honor, so according to the testimony, the shell casings that were not fired from the Smith and Wesson, the other shell casings from the body, they match back up to a Glock 9mm. He's not able to test shell casings to the that were found from
In this
one
particular
scene.
case, they weren't able to do that.
Yeah.
Okay.
However, 2A, and I believe the other one, Your Honor, that was fired from the Smith and Wesson, from Jacob Ingram's firearm, Your Honor, matched back to obviously the firearm. Your Honor, we have asked for parties to a crime. I know Mr. Ingram is not on trial right now. However, if the jury also believes that Mr. Ingram fired his weapon, killed Mr. Carr, then also Mr. Johnson would be found guilty, could be found guilty as well. So we believe that we've proved our case, Your Honor, at this time.
All right. Thank you, Ms. Russell. So, Mr. Brown, I think you have outlined your arguments for a closing argument, but the directed verdict standard is to look at all the allegations and inferences and make those in favor of the non-moving party. And so here, I think there is certainly enough of the timing of the cartridges. That's a question of fact the jury can consider, as well as who it is on that surveillance video. So I'll deny your motion, but it is preserved for the record.
Yes, Your Honor.
So now we would turn to the defense opportunity to present evidence. I'll instruct the jury when they come back. The defense does not have any obligation or burden at all to present evidence, but that they can. And the first thing I think we need to take up is, Mr. Brown, you've indicated that Mr. Johnson would be the only potential witness for the defense. So now, Mr. Johnson, we've reached that point where I need to ask and go over some questions with you. All right? So he doesn't have to stand. That's fine.
Oh, okay.
The first question I'd have before you, Mr. Johnson, is do you understand you have a right to testify? And if you want to testify, no one can prevent you from doing so. Do you understand that no one can make or compel you to testify? That is, do you understand you have a right not to testify? You understand that it's not your lawyer, but you personally are the one who decides whether you will testify or not. Do you understand if you do not testify, then upon proper request by you, the court will instruct the jury your decision cannot be used against you? Do you understand if you choose to testify, you will be both examined by your counsel and cross-examined by the state? Do you feel you need any additional time to think about whether you want to testify?
He asked me if he can speak with me. Do you still?
I can speak with him for a second.
All right. I imagine you want more than a second. How much time do you need?
About 5 minutes. Just speak.
All right. We'll take 5 minutes. And are you going into the back to talk to him?
Yes, Your Honor.
All right. We'll be back at 10:35. We're off the record in recess until 10:35.
Oh, the light, yeah, it is. Mm-hmm. Clip. I'm just gonna take it out. I'm just gonna say these.
You don't really have to
Seems to me like we would keep juror 11 for today. We could bring back the jury.
Last of the jurors. Jurors are present, Your Honor.
We sure about that?
All jurors are present, Your Honor.
Thank you, Deputy Scott. All right, members of the jury, the state has now rested and has no further evidence to present in its case in chief. I'll remind you of something that I talked about at the opening of this trial, which is that the defendant has a presumption of innocence and that he has no burden of proof whatsoever, and that burden never shifts to the defendant to prove his evidence. So what that means is the defendant doesn't have to present any evidence at all, but the defense can if they would like to. So at this point, we shift over, and Mr. Brown, is there any evidence to present on behalf of the defendant?
No, Your Honor, the defense rests.
All right. And so what that means at this point, members of the jury, is that the evidence is closed in this case. The next thing that we need to do today for you would be to prepare for closing arguments. There's something else we have to do outside your presence again, which is have a meeting about what is the law that applies to this case, and that takes some time. And so instead of starting closing arguments, stopping for lunch, and then picking them back up again, I think the best thing for us to do would just be to take a longer break for us to come back after lunch and start closing arguments at that point. So what we're going to need to do at this point is we'll break until 12:45. And so we're going to be working, and then we're also we don't know how long that process lasts, but come 12:45, we'll be ready to go to start closing arguments. And after that, we'll charge you on the law, and then the case will be in your hands. Any questions for me before we break here? All right. Seeing none, then we'll see you back ready to go at 12:45. Thank you so much.
All right, the jury.
All right, let's transition to the charge conference. I believe I'm now on Courts Exhibit 4. Get a thumbs up on that. So I'm marking as Courts Exhibit 4 a compilation of both sides' requests to charge, as well as a few that I thought we want to consider as well. I've got that as a 51-page single-sided document that I'm tendering as Courts Exhibit 4, and I've also provided a copy of that for the parties to review as we go over this charge conference. And generally how I've done these, and just in the interest of efficiency, since so many of these are kind of pattern charges, is I'll just go through them, and the moment you have an objection or a concern or something you want to raise, just say it. Otherwise, we'll just keep continuing right through them. So, starting off on page 1, we have the pattern charge on the indictment and instruction. And does it contain all the... I think we might need to fix something there. I don't know if that matches and tracks the charges in the indictment. Let's double check.
I don't think it does.
Right. So there's only going to be 3 counts of felony murder. And then there's 1 count of aggravated assault and 2 counts of possession of a firearm and the convicted felon. So we just need to change from 4 counts of felony murder to 3 counts. Is that accurate?
Yes, Your Honor.
Yes, Your Honor.
All right. I'll also note that I'm going to provide a copy of the charge that we agree on to the jury, condensed where we don't have the titles, as one, 8 or 9 page document, and I'll let them know that at the outset. All right. Page 2, pattern charge of plea of not guilty, which I'll give. Page 3, pattern charge on reasonable doubt. I would strike the parenthetical in the 4th paragraph about when a defense is raised by the evidence. I didn't hear about an affirmative defense. I didn't think that one was being raised. Mr. Brown?
No affirmative defense.
Okay, so we'll strike the parenthetical on page 3. Page 4, grave suspicion requested by the defense. When it comes to that one, I kind of just consider that on a case-by-case basis as instructed by our appellate courts, but noting also, as pointed out by our appellate courts, that charge is essentially duplicative of reasonable doubt. And in this case, I think reasonable doubt covers the charge as an accurate statement of the law, and so I would not plan to give grave suspicion, but I'll note, Mr. Brown, your objection for the record.
Thank you, Your Honor.
All right. Page 5, jury, judges of law and facts, pattern charge that I'll give. Page 6, evidence generally is the pattern charge, as well as page 7, on direct evidence is the pattern charge. I'm not seeing anything that needs to be tailored there. We turn to page 8, we have credibility of witnesses. Maybe this is a good point for discussion just generally. Is there anything we can... Let me put it to you, Mr. Brown, was a witness a witness who testified? Is there any witness whose credibility you believe is being called into question, or is it more of a quantum of proof?
None. I have no issue with the credibility of any of the witnesses, Your Honor. Just a question of, did they give testimony that could get my client convicted? That's an issue.
So we'll see how that affects the other charges, but that's kind of what I wanted to talk through. And so in that situation, then it seems that we may not need the pattern charge on page 8, the credibility of witnesses. All right, so we'll strike that. We have expert witness pattern charge, which I'll give. And then playing off what we just talked about on page 10 and 11 and 12, we have pattern charges for witness impeached, witness attacked, and witness supported. And if we don't think those are issues at play, then I would say we would strike those 3 charges. Any thoughts, Mr. Brown?
That'd be fine, Your Honor.
Okay. Turning to page 13, we have prior statements. I know we have prior statements. Well, no, we don't. We just prior statements in the effect of Mr. Johnson gave statements, but it's not what this charge was intended to cover, of comparing and contrasting trial testimony. So I would think 13 may also be struck. All right, seeing a yes from Mr. Brown.
Yes, sir.
All right, page 14, single witness, pattern charge, I would give. Page 15 is a statement by one defendant at a joint trial. I don't think we ended up having that. Mr. Ingram didn't testify, so I would strike page 15. We move on to 16, which is the defendant's choice not to testify. And I would propose, since Mr. Johnson did not testify, striking the first paragraph. And it would just read, defendant does not have to present any evidence. If he chooses not to testify, you can't consider that in any way.
Yes, sir, that's fine.
Any thoughts on that?
No, I think that's fine, Your Honor.
Okay. That's what we'll do on 16. Good. Page 17. This gets into voluntariness and Miranda of custodial statements. We do have a custodial statement in this case. And the issue of voluntariness and Miranda and whether that's going to be something that is considered by the jury is only required if the defense requests it. So to you, Mr. Brown, for pages 17 through 23, is there a request for that kind of packet of charges relating to voluntariness and Miranda?
Yes, I request that they be given.
All right, let's take a closer look at that then. So 17 is the pattern charge on just generally statement of a defendant. We have voluntariness on 18, which I'll give. We have circumstances of the statement on 19. We have a parenthetical here. I imagine I would keep the parenthetical.
Does it apply?
Yeah, I think you should keep it.
Was there an illegal detention?
Yeah, I don't understand why this is. Why this needs.
Well, Mr. Brown's asking, I know he conceded it at the Jackson-Deno phase, but ultimately that's still an argument he could make to the jury in closing, and he could ask that the jury have to consider voluntariness. And I don't think that that's something that absent that if the defense requests it, I don't think that's something that we cannot have the jury consider, unless you can show me law to the opposite. So I think it's kind of all or nothing with these. If we're saying you want the jury to be able to consider the voluntariness of that custodial statement, then all the aspects that come into whether a statement's voluntary or not come in. So
I agree, Your Honor.
all right, so 19, I'd give it it's in its entirety, including the parenthetical. 20 talks about the burden of proof of voluntariness, pattern charge that I'll give. 21 talks about the constitutional rights. We have a parenthetical about whether anything he said, wrote, or signed could be used as evidence against him. I don't think he wrote or signed anything. It would just be said. So we could strike those two other parentheticals.
Yes, Your Honor.
Page 22, burden of proof as to rights also falls on the state, pattern charge that I'll give. 23, conditions precedent. I would strike the parentheticals at the end of the paragraph because Mr. Johnson did not testify and those aspects don't come into play.
I agree, Your Honor.
Otherwise, I'd give the entirety of 23. All right, then we move on to 24, which is limiting instructions. I did give one limiting instruction at the request of the state and then another kind of sua sponte about burden of proof right before the state defense rested. And so I would say we would tailor that as sometimes evidence is admitted for a limited purpose, strike the part about or against some parties or not others, and include the part or for some counts and not others. Such evidence may be considered by the jury for the sole issue or purpose and only for the counts for which the evidence is limited and not for any other purpose. So that's really just in reference to the prior conviction. Any other thoughts about that one?
No, Your Honor.
Okay. Moving on, 25. We got prior difficulties. I know that was the subject of a motion in limine, but I didn't really see that come out on as the evidence or in cross. So I would say we strike 25.
Yes, Your Honor.
Okay. 26, we get into identification and reliability. Mr. Brown, are you asking for this one?
Absolutely, Your Honor.
All right. Well, as a pattern charge, we'll give it in its entirety. 27. I don't recall offhand whether the state requested party to a crime, but I imagine that's going to.
Oh, wait. We're on 20,
Page 27 is identification, but the parentheticals relate to party to a crime.
we did.
Okay. Then I would say we're including the parentheticals on 27 and giving it in its entirety.
Yes, Your Honor.
All right, moving on. We have 28, where we're starting to get more into defining the crimes. 28 is the pattern charge of definition, which I'll give. 29, pattern charge on intent, which I'll give. 30, no presumption. It's the pattern charge. I suppose I'll give it along with the parenthetical.
Yes, Your Honor.
All right. 31, presumptions and inferences. I don't know which party requested it, but it's a pattern charge. If you think that plays into this in some way, I can give it. If you don't think it plays into it, we can strike it.
So did I request it? Did the
And
state request it?
If you wish to do so, that person's will. Oh, yes.
Was this a state request?
I believe it was the state's request.
You still want it?
Yes.
All right, I'll keep in page 31, presumptions and inferences. Page 32, we've got parties to a crime.
Party to a crime in this case. Well, there is, but
Yes.
that's a trial.
Do we want to strike D from party to a crime? I don't know if I really see how that one factors in.
Yeah, I don't think this D,
Yes, strike D, please.
Ms. Russell, strike D?
yes.
Okay. We'll strike D from party to a crime. And give the rest. Moving on, page 33, we have mere presence, pattern charge, which I'll give. Page 34, mere association. Pattern charge, I'll give it. Page 35 is multiple
I
defendants.
think this one. Yeah, I don't think this one,
There aren't multiple.
there aren't multiple defendants on trial.
All right, there weren't in this trial, but I was wondering perhaps if the last sentence, you, the jury, must determine the guilt or innocence of each defendant separately. Is there something along those lines we want to have in there, or just want to strike it entirely?
Strike entirely, Your Honor.
Okay, Mr. Russell?
Yes, we can strike the entire thing.
All right, we'll strike 35. 36, malice murder, pattern charge. I imagine I would include the parenthetical without justification, even though justification hasn't really been raised by the evidence. Or I can strike the parenthetical. Any preferences? Let me start with
It
this.
should be struck. There's not like there hasn't been a justification defense raised.
All right, then we'll do that. So striking without justification on page 36. Page 37, motive, pattern charge that we'll give. Page 38, we have felony murder. And the predicates for the felony murders are both listed there: ag assault with a deadly weapon and possession of a firearm by a convicted felon. I don't know if is it worth distinguishing between the two types of possessions of a firearm by a convicted felon, or are both parties fine with how it's described in this felony murder count?
I'm
I was-
okay.
Yeah, let me just always start with the state when I'm just
Yes.
putting a question out there. Ms. Russell?
I think it's fine with how it is, Your Honor.
All right, Mr. Brown, any thoughts or concerns?
I think it's fine the way it's written, Your Honor.
I couldn't really think of an alternative, even if we wanted to distinguish it at this phase. We'll distinguish later when defining them. So we'll give 38 as it's listed. Page 39, we have causation and felony murder, which is a pattern charge. It wasn't requested by either party, but I think it plays into defining the offense of felony murder Ms. Russell?
I actually think I argue this without, so, yeah, we can keep it in, please.
No objection, Your Honor.
Okay, 39 stays in its entirety. Page 40, we have aggravated assault with a deadly weapon. That is the aggravated assault that's indicted. I think it's tailored to the charging language, so I would give that in its entirety. We have page 41. Firearm when used in the way a firearm is ordinarily used is a deadly weapon. And the language of the indictment just simply says firearm, just I'll note that. So I don't think we have any variation there. So I'll give 41 as written. 42, we have possession of a firearm during the commission of a felony. It appears to be tailored to the indictment, matches the language. So I'd give it as written there. 43, possession of a firearm by a convicted felon. I think we need to, yeah, we've got a little carryover. We got to fix this language here.
The commission of a felony, we actually have it, on person, excuse me, on person and on and within arm's reach of accused person. That's how we have it in the indictment, count 8.
Okay, let's double check the pattern charge just to compare them. So we're going back to page 42 here.
Yeah, sorry about that, Joe.
Okay, so the pattern charge does include both options as parentheticals, and if it's indicted that way, then we could have on 2, on his person or within arm's reach of his person. Is that what you're requesting, Ms.
Yes, Your
Russell?
Honor.
Any thoughts on that, Mr. Brown?
No objection.
Okay. All right, moving on to 43. Because there was a stipulation as to the prior felony, I'm wondering if we need that second line about what are felonies?
Yeah, I think we have to take that out
Yeah.
because we didn't, that was the whole purpose of our stipulation, so they wouldn't
Right.
know.
So we would strike I guess that would be the second paragraph that lists what are felonies.
Yes.
And leaving the rest for the purposes of this offense, a firearm includes any handgun.
Yes.
Yes, Your Honor.
Okay. Do we need to talk about the second type of possession of a firearm by a convicted felon, the 133 count, and somehow have that addressed in this as well?
I think we do, Your Honor. It adds in that extra element for the state that said prior offense
Right.
involved possession of a firearm.
So I think what we would do with that, there is no pattern charge. So let's take a look at that. I think how we would do this is we would say, for possession of a firearm by a convicted felon, as alleged in count 10, state must prove, and then list those 2 elements again. We've already struck that second paragraph. Then we'd kind of copy and paste it and say, for possession of a firearm by a convicted felon, as alleged in count 11, and then let's look at those elements and see what we need to play with. I think that it would simply be that for the second element, it would be after having been convicted of a felony involving the possession of a firearm.
Yes, Your Honor.
I mean, are there any other elements that 133 has that 131 doesn't?
Excuse me, that's the only one that the state would have to prove, the extra. for the
Okay,
130.
and then after listing that essentially kind of twice, then we have the line about, for the purposes of this offense, a firearm includes any handgun.
That'll be fine, Your Honor.
Got all that? Got it all. Let me double check. Says possessed. It doesn't have the arms reach in the pattern charge. They're just possessed.
That's how
Charge. Let's just do possessed. Okay, so moving on from 43, we get to 44, venue generally. We'll keep the parenthetical, crime committed in Fulton County. And I'll give the rest as written. On 45, I kind of I've wondered if 45 is really applicable when we're going to provide them with a verdict form. It's almost like the instruction is just designed to teach them how they would write a verdict form from
But that's not
scratch.
really how you.
But we give them one. So I don't know. I would propose striking 45, which reminds me we need to put together a verdict form and present it to both parties for agreement. But put that aside. What do you think about the pattern charge on 45? Do you think we
I mean,
need?
I always keep it in, Judge. I mean, I haven't seen it taken out, but I do understand because that's not really how they're going to write their verdict.
It's going to be an X.
A check or X,
Yes.
yeah, so.
Agree, Your Honor.
Do we want to keep it out? All right.
It's strange.
45 is gone. Page 45, verdict generally is gone. We'll agree on a verdict form before we begin closing arguments. We move on to 46. Court has no interest in the case. Standard charge. I'll give it in its entirety. Same with 47, and I'll just keep in the parenthetical if we just want every single possible iteration of sympathy. And I'll give it in its entirety. 48, sentencing responsibility 4, pattern charge that I'll give. 49, deliberations, pattern charge. I don't see any tailoring needed. And unanimous verdict. I'll keep the parenthetical, give everything else. And then we've got retire to the jury room, and that's when then I would keep back for the purposes of today, I would ask 29, juror 29 and 32 to stay back with us. Okay, did we get
Yeah, we fixed that the dummy right now. So we just.
all right, so are there any other instructions or requests to charge other than what we've covered so far, Ms. Russell?
No, Your Honor.
Mr. Brown?
No, Your Honor.
Okay, we'll put together a compilation with all these revisions, and we'll give you another copy so you can review that before we go into closings. And I'll also have one tendered as Court's Exhibit 5, which will be the one that goes back with the jury. Do we have an extra dummy or redacted indictment already prepared for them as well?
Oh, I'm sorry, yeah, I thought that was the dummy indictment.
Yeah, I just wanted to make sure we had a clean copy, maybe entered as an exhibit. I don't know if we ever actually did that because we printed it off a couple times.
Hopefully this is a good one. I'm gonna get this felony languages.
Here's 4.
I'm going to take off these last pages and just have the indictment.
Mhm.
If you wanna,
I think that you already showed it to me. Thank you.
yeah, I think.
Oh, we do have one? Okay, we might have one. I'm wondering if this is the most recent version. Let's see. The last thing was the Falunis. Okay. Wait. All right, it looks like we did already have one admitted as Courts Exhibit 1. However, Courts Exhibit 1 still had that kind of extraneous warrant information, charging history, and witness list on the back. And so I think the proposal by the state was to remove those pages so that it's solely the counts.
Yes, ma'am.
So I'm going to remove these pages and we'll just keep Courts Exhibit 1 as originally submitted. All right. So as I mentioned, we can work up a verdict form and I'll show that to you before we come back for closings. Two more things I can think of. I do have that laptop here that I mentioned before. I'll just leave it here. Y'all can take a look at it, see whether it's agreeable to both parties. But we still need a thumb drive or something that's actually going to have the exhibits you want them to be able to review if they have it. And of course, we need to be clear exactly what exhibits are on that thumb drive.
'71, '71. Oh, wow, look at you. It probably needs to be updated. You know, I added some stuff and took away stuff, so we need to just make sure.
And also over the break, we need to test it to make sure it actually plays these videos. I even had to do that. This thing's brand new.
Oh,
So,
okay.
so we'll just leave it with you. And if it doesn't play the videos, then we'll just maybe give up on it for today. But for now, I'll leave that here with y'all for the break.
So if I could just, I think it was just exhibit 65, exhibit 71, and exhibit 71A are the exhibits with no speaking, those are surveillance.
Okay, let me get those again. So you would be proposing to put on this hard drive if we do get the laptop put out, which exhibits?
65, 71, and 71A.
All right. Mr. Brown, any thoughts, reactions to that?
Just 65 is
65 is the surveillance video from 878 Norwood Road.
no objection.
71 is surveillance video from 1955 Moreland.
No objection.
And 71A is a compilation video.
No objection.
All right. So when we come back from the break, I'll ask you, Mr. Brown, and state whether you think this laptop's going to work, whether we've had a chance to play the video on it to see if it does work, and we can go from there. And on that note as well, I think we could go ahead and take this time to go over which exhibits we think do go back and which ones don't. And then I'll also open it up to the floor to see if there's any other issues.
Okay.
All right. So it's probably easier to say which exhibits do we think don't go back.
The demonstrative aids do not go back, Your Honor.
I would agree with that. They can be used during closing, but they wouldn't go back to the jury. I would think the 911 call is not going to go back, which is exhibit 1. And again, the other videos with audio, so the Defendant's interview, 76. There's body cam, 63. Any others, Mr. Brown, you want to note for the record, you think that don't go back?
63, which other one? I'm sorry.
I'm just pointing out what I think may have the video and audio, which wouldn't go back. So 63 looks like it's the body cam from Officer Gilbert. 76 looks like it's Mr. Johnson's interview with the detective. But really, this is up to y'all. You know, you tell me what you don't want to go back and we'll go with that.
I absolutely request that the audio, the interview with my client do not go back, Your Honor.
Okay.
No, that's not, yeah.
Right. Well, here's what I'll do then. I'll leave it up to y'all over the break to have that stack of exhibits, what goes back and what doesn't, divided, and we'll note it for the record when we're done with closings.
That's fine, Your Honor.
Thank you.
Okay, Ms. Russell, anything we need to take up before breaking?
No, Your Honor.
Mr. Brown?
No, Your Honor.
Okay, we'll be back. Let's come back a little bit before 12:45,
Yes, that'd be fine, Your Honor.
and we'll get right back to it. We'll be in recess.
All the photos, do they get to, when the jury goes back in deliberation, with deciding what evidence goes, they get to see.
No, I can go back. I just seen your email. That's interesting.
Yeah, stay.
You actually did it.
I
Yeah.
don't want your statement. I don't want these big old demonstrative evidence to go back, but you know, pretty much everything else can go back.
I could take some food if you, okay, we could do that. Go eat, go get something to eat and then come back like around, come back around 12:15. Yeah, come back in an hour. Yeah, cause let everybody eat and then get our minds together and then we could do it.
Okay.
Yeah.
Just not
Everything except audio, but we'll go through it.
everything except all that.
Yeah, yeah.
Yeah, I'll just come back at 12:15.
Okay.
I think so.
Mr. Brown?
Okay.
That's why I've been
Doing that.
It's almost 2 hours.
Miss Kenya, Miss Lady, you see she does all the girls' hair. Look at Dilly.
She gonna leave it because she left it yesterday.
Yeah.
Oh, I ain't gonna leave my baby sitting here.
It's just the front room. Why all of a sudden my throat? Oh my gosh.
So then you said 71A.
71A, 71, and 65.
You're
Where did this come from? Target. But
No,
what, Good and Gather, it's Target.
but I didn't get it when we came here on July the 5th, but gave it to me.
Oh,
We were.
Go eat. You trying to go get some food, bro?
I thought you were gone. July 5th. No, you came back? I know about that Asia was gonna do it. No.
My bad.
Oh,
But Richard said, well, I'm in same status.
oh, good,
She
Richard.
agreed to stay, but I have a whole story to tell you.
Oh,
Don't stop playing, gonna get you one of
this.
nice take home, man.
Oh, that's so crazy. Where you going?
No.
Mama?
Oh, yeah, where you going? Buddha has shown me crazy and not years. Asian, Korean. You want one of those?
It does not matter.
Are you
I
going?
mean, but
Where you
where are you going, Quinn?
What's your offer?
So you say I will.
12:45, right?
Yes, 12:45, so we got some time.
Yeah, got about 2 hours, over 2
Yeah.
hours. You look very loyally. I noticed yesterday and today. You kind of know.
I have been asked a couple times. I haven't thought about it at the time,
Okay.
but yeah, I've been asked a couple times.
With your expertise with equipment, I think that would be a strong asset.
Yeah, I've been thinking about it. It's literally been rolling through my mind.
I think it still plays because it's going through the podium.
You should give us some thought.
Can I mute the phone?
I'm gonna keep thinking about it.
It's the actual,
I've been asked
it's
a
not the
couple
mic.
times.
It's just,
Never,
yeah.
thought about it.
We could use you fighting these battles. Take care.
You too.
We're not talking about what you care. What I'm talking about. Just please. We say yes, yeah. We don't talk about. But some.
Should we, put it in before that?
Oh, yeah, put it into DoorDash. Okay, we're just,
What you get? Wings and like, you want your finger? Which?
wings from American Deli. I mean,
You can go find some. No, I am. I know.
it's on DoorDash. Okay, all right, y'all. Let me focus on this. Let me focus. Oh, it is right there. Let me go into the little room. Whatever you, yeah, because I need your help. I'm trying to figure this out. And then are you gonna bring in, yeah, and then we can talk freely.
Yeah.
All of some stuff. Deputy Scott.
You good?
Can we go into this little room? Just this little room right here?
Yeah.
Perfect, thank you.
I'm gonna leave this in here while it's loading up.
Okay, perfect. We're taking-
Just put on the record, it's that weren't on there. 'Cause I was like,
No.
it's still in this phone.
Which one?
The ones that call it or on.
Oh, yeah. No. Yeah, we got it.
That was good. Cause I was checking them this morning, I was like.
Yeah, there was some that we didn't put in, and
So
then
that's
one skip, one night.
Yeah.
So, yeah.
And
You taking your charger? Oh.
Yeah.
Yeah.
He know what, he had a bomb, because we're.
Oh, did she get the notepad? No.
So you would think that the other agency, you know, back, got own something going on to me. No, the troopers don't really like. Exactly. Yeah, I was down there, Jack White, I talk to him every day. Young dude. I got all this. I'm on some. He said, he get relief, this relief from middle Georgia. And then they got a post where they buried it.
Yeah.
Ain't no great.
When I was with Pilot, man, and she green, that's what hit, but man, when the mattress hit Savannah, man, I went down there, man, that was, they made $2 grand. I had to pay for nothing, put us up, hotel. Even Johnny Powell, who was the Johnny Powell, had a tank, I kept gas in my truck up. I went down there, man, it was so dark, I got to, I had to go to the airport, and the troop was right there, I said, man,
What
hey,
up,
man,
show?
how'd you? I said, I don't know.
Man, I can cover.
Man, he was so good. You know what I'm saying? They looked at me like, what you doing down there? I said,
What y'all
man,
doing?
yeah, we doing.
She work at South.
I said,
I ain't gonna say she's my home. She ain't nothing wrong, right? Sure, I got South Fulton.
Man, I went down there to be careful, man. I know that. Man, I went
Oh,
down
what
there.
happened?
Man, they had a tree in the middle of the road, man. That the trunk of the tree
Oh, yeah,
had to
she
be about
does
this
like
high
gangs and stuff.
into there. And all I saw was this damn truck, man, it smashed. I wonder if that person dead. You know, they made, man, yeah, it was pretty crazy, man.
That was helping us out doing what? Doing what was she helping us with?
Man, you got people, she was down, man. It's-
Oh,
He joined.
let me see.
Judge said,
Which type of record she was
Yeah,
trying to get? That determined who it was.
you better.
That was evidence. That's gonna be Helen Weathers.
Like Tim Scott.
Yeah, you gotta be token.
You gotta poke it.
You gotta be token. But man, that's all good, man. No, same old, same old. You're all good. Yeah. I'm gonna submit it on Thursday. I got everything ready. You start off with that. They pitch.
I had a buddy, he was a sergeant here. He
It's
started
not
out with the cab. He was a cab. Overnight, he never
It's been upgraded still. We found, remember that guy Brown couldn't find? Found us.
He quit.
Yeah. So they just started the retrial for that case, so that was good.
He got
All the way through it. I put the trial, just saying. After I retired from the Navy. Yeah. When she got home with Carl, but I got still on truck. Everybody, I said, there's a lot of us that can't come down. She got on, and then we on Friday, they got hired Friday. You're going to go into jail. I think police.
You know what I'm saying? Oh, yeah.
I think one of the reasons why they didn't really bother. No, it's Cobb County. Wasn't no diversity with them. And they was, that was during the time where they started talking about diversity, having all the solutions or whatever. So they didn't really bother, and then they didn't take a chance. They didn't say, this is an asshole right here. So they didn't take a chance. I'm looking for a lick to get some money.
Jason.
I was there, hey, so they kind of took me alone. But other than that, it's decent.
You all can talk freely. I'm turning the mics off.
Okay, I was gonna say y'all on live.
You got to deal with the little racist.
What's going on, y'all?
Yeah, I'm good, yeah, I'm good, man.
Nothing much. Nothing much. Okay. Thank you. Oh, can I go ahead and stay for this one now? Oh. Hold on.
I can stay for this one.
Yeah, but one of those doesn't go in there.
Oh, which one? 64A or 74A? Because I was asking you about 74A.
That doesn't go in that app. Yep, these are all together in that.
Okay. So these are not going back? No?
No, those are demonstrative, they're not going back.
Okay. They'll stay in the little slotties then.
Maria. Outside. Yeah. She might knock.
So, Mr. Wright. With the W. I'm gonna log these. Does your investigator have to come in here?
Here, take this so you can be working on that while we're closing.
Okay, well, so I'm loading it up now.
I thought
Oh.
it had been loaded.
Well,
It was taking
one of the
forever?
videos is taking its own.
FYI.
Oh.
You said do our investigate.
Back.
Oh.
Okay,
Thank
Okay.
you.
all right. Thank you, Mr.
You said do our investigate after what?
Are you gonna come back? I'm not gonna give you all of them, I'm just gonna give you the full ones, like the gun.
He would have to come.
He would have to come in, so I'm gonna prepare, evidence of.
Oh.
And put the ones on. And hi.
Oh, can you get Maria? That's Maria. We're coming, Maria. Oh, I can get it. Maria?
I need. I was smelling something.
You smell it?
I was smelling like fries or something, but I wasn't sure.
What you
I saw the cup.
We were in there. We were over there. I'm gonna put my cup. We were in that conference room. We didn't even eat in here.
I just smelled
Mm-hmm.
something.
So you said we're including everything, but the thing has audio to it.
Correct. Yeah.
And the demonstrative.
And it's a much.
And the demonstrative. So we can start
want
from the
this?
beginning. No, I don't need that. No,
Okay.
because I was starting with number one. All of these. All of these. Start with number one. Let's start with number one.
Okay.
Let's go in order.
Number one is the CD.
Yeah.
We don't need that. Number two.
Oh. Number two, you got to do the list.
Do I have the exhibit list? Yeah. Here you go. Here you go.
Number two is gonna be the CAD report. CAD report. What's number three?
Number three is the photograph in front of 1955. So 3 through 13 are photographs.
Okay, so I'm missing number three. I got number four.
What's number three? You need number three?
Photograph of front.
Oh, it's probably in there.
It's probably, cause I remember I was mad, they took all my stuff.
Yeah, I did. Yeah, see, I didn't have that one.
And then I have some of the stuff right here.
I don't have three. You don't have three.
Okay.
It's not in there. It's not? No, because I went through all of those.
Photograph of front of 1955 Portland Avenue.
Yeah, that little picture.
Yeah, I went to those, that's not in. That was with, Mr. Benson.
You found
Is
three?
that three?
It's just stuck to the.
Oh, that's why. I was wondering where the printer jumped.
All right, any other ones missing?
So that's 3 through 33 should be followed.
I don't like these nowhere near defendant. They pop up and. Mm-hmm.
What comes next?
Next one at 33 should be, my bad, 34 should be photograph of Shamrock Garden. For 46. Uh, 48 should be photograph of TNR.
48.
Like 48 and 59.
That's 48.
Yeah.
Here.
I'm gonna clean up.
You say something about 48?
Oh, yeah. It's right here.
Yeah. 49. 48.
How is Siri doing, I wonder?
Well, she did Jurors.
I think so. I haven't spoken to them.
Alright, 60 should be still shot. 60. Okay, 62.
I sure do. That's gonna be 5.
62.
Mm-hmm.
See 63 is body cam
You
video.
can just put that on the stack of exhibits that are going back.
Or is firearms report.
Firearms report is up there. Cause you remember I gave.
Yeah, 64.
Yeah.
Yeah, she just gave.
Who knows, Mr. Brown in the back, or
I hadn't seen him. I was.
65 surveillance video.
Okay.
66 through
say what? I didn't catch it.
70 is still
that's
shot.
true.
71 surveillance video, 71A is compilation video.
And all these documents from commission.
72 is still shot.
All these documents.
72 through
All these things I gotta sign.
Oh, the first one was blank.
Yeah.
Well, I'm signing it anyway.
um
Get blank.
77, 78.
Sign it again.
I mean, 80 is the.
We don't have a defense attorney. I bet they'll turn on the light for us. We can give them a few minutes.
Mustard, or no, 82 is mustard, what's 81?
Murder weapon gun.
Okay, good.
Um,
You have the key?
83 is shell casings.
God,
84
the
is shell
clock
casings.
in.
85, I'm sorry.
Shame.
No.
What if I lost?
Oh, no, bro. Nah, with that.
85. 86 through It's 1:30.
No.
My bad, 1:15.
What's up?
116, right?
And 1:16 she's still shot.
You got this last still shot?
116?
That's it. Okay, that's that.
Thank you, Quentin.
And then I have these that need to go back, but I'm gonna use them for my closing. 121, all of that.
Everything but the.
Oh, and these. Oh, yeah.
Yeah, we put that in.
Is there anyone in the back? Is Mr. Brown in the back? Oh, okay. Just double check.
Demonstration. That's the court's exhibits there. Chill.
I'm staying.
And then I also, don't let me forget, I have the indictment, I have the, yeah, I have it.
Huh? Ms. Vortis, if you can hear us, can you try giving Mr. Brown a call?
Will do.
It's,
So we don't know whether it can play videos or not yet?
Not yet. It's
Okay.
almost done.
we can hook up mine and just see.
'Cause we don't even know. I don't even know if that laptop's going to work. No. Da-da-da-da.
So is Wi-Fi complete, I guess it's completely. It hooks up to my either. I don't have a block.
So that's my, oh. Yeah, that's pretty good.
I got it. Okay. Okay.
That's it?
Okay.
Look on that side. Mine, that's it
Yeah.
right there.
Yours.
Yeah. Mm-hmm.
So it plays the video from Savannah's 1955. It doesn't play from.
Put it in, okay, how you know? Put it on VLC. Here.
So 1955 Moreland can play, but no wood won't play.
What about the compilation, 71 A?
71.
What's that?
Like your setup.
What happened, John?
71A plays. So the only one that don't play is no.
Oh, yeah.
All right, I'm told Mr. Brown was mistaken on the time and he'll be back. He's coming this way. He says 15 minutes. Who's? Richardson? She's got the one clock. She bought him? Oh,
And maybe can
I'm
we?
telling you. Yeah, we're very influential here. Do they look like this?
Same thing we have our peers.
Yeah.
Jurors is still shot.
Yeah.
Really?
But I stole that from federal court, so I can't say I got origination credit.
You're the only one complaining.
But I played through DLC. You want to play it through DLC too? Did you right click that and see if it has another program that you can play with?
What?
But I told you the time that he was coming.
Okay.
He got the standard.
But can it play on any of them, or there is no other one? Can we try movies?
When I don't have a poker face, it's because I don't want a poker face.
We were laughing at. So strange.
Whitaker.
Strange.
Miss Russell, you got your PowerPoint working?
Sure. I'm gonna, and I'll say this in front of him, I'm gonna go last, just one
Okay.
closing.
Got it. Hmm?
They requested transfer.
Who did? Well, yeah. I mean, it's part of a motion for new trial. Or forward that to me. It's kind of proactive of him. Yeah. No. I'm just curious about that one. Who is asking for what? One. Is there something he's? And so he needs the transcript for this one. Why don't you, instead of a certified, why don't you ask him if there's a specific part of it he wants? You can just give him your rough draft. Because I know your certified takes more time. Just ask him, is there something specific he wants? And that should only take a minute or two, right? Okay, that's just pretty routine.
Voice test is no respond. But I know like in order to play the videos, sometimes you have to close out the program. It eventually ends up saving, but I'm about to reach closing, you know.
Yeah. Why don't we just check in and see if we got them all?
What did you say? Right. Because I'm about to be on this one. Or maybe so. I don't know. You can. Are you gonna say? Where did you change? Maybe because it's so low. She said you can. Oh my God. Constitutional right. He can do it to them because the best is in there. Oh, but I was like, I was like, what time is she? Oh, she didn't. What she did?
And then she's away for a second. She goes, but let's stay home. She sleeps a lot.
Really?
Cause she's like,
Dylan also. Oh,
yeah.
that kind of woman. Right.
Yeah, she chose me.
The pop on. So if you walk in late, you know, you just sit there when you get there. And so, you know, and I kind of like, and I do everything.
Yeah.
And I'm just let us go.
They all take it. Oh.
Oh, yeah, yeah. I saw that. How many more minutes on the? No. Do y'all breathe? I mean, no. When they do it. How do you know?
All the breaks. This is just so sick. I'm like, should be to come out. Like it should start panting. And you'll know it's happening in the day. She's like digging, panting. She's like, what's gonna happen?
You say what? It's all there.
First 2 times I was there. His mom did it. And the last time I was home.
If we just she deliver, you don't help or nothing. You
The
look.
first 2 videos, picked up his mom to do everything. But this last one, she ripped that up, ate it, and she did it.
Really? I would have been like, oh my gosh.
I know.
How y'all know what to do?
Can
Okay.
Literally, when we went to our reader, so she had a letter to Michelle.
Look, what type of dogs? She would have the same. Like, she will find everything.
That's how she.
Be careful. Like,
Yeah.
I'm like, where you find this?
Like downstairs, I get on a lot. But upstairs.
I might do that. I felt like I was ready to. That's, yeah, they're both good, like, good. It gotta be that sound. They said I'm only doing one. We got the case. What else? Virgin. What? Who? It's not familiar. Who? Virgin Hall. No, because I have Virgil Fletcher. Okay. It's in this court. Mm-mm.
What's your name? It's the teacher.
But
It's teacher.
it's got me, yes, but she, he's gonna understand.
Yeah. The teacher.
Huh? Oh, yeah,
You know.
Mhm.
Yeah. It was like a she real big.
You try to be funny. That's true, that's what he went, all right. That's tough.
Taking all the time, exactly.
Ms. Waters, can we give Mr. Brown another call for an update?
Yes, Your Honor.
He don't be like 20, 30 minutes. If you keep it on, I'm gonna go.
He said, which one is she? I said, not to keep me. He said, "Damn."
What's the name, the email? I am. Which is on
Saturday.
this side of the 20th. Yep. It's in Colorado, right? Or no? It's in Mapleton, yeah. Wow. Are you going, oh, that's when you read. Yeah, I'm going.
He's the one. Usually we'll take that.
Yeah, it's already out there.
Yeah. Okay, there we go. Oh, I don't see that.
Ms. House? Everyone. I think that's what they do.
Mm-mm. Host. Is this husband like hosting?
Yeah.
He's so funny.
We got Mr. Johnson.
I apologize, Your Honor.
One day before. I'm coming. Putting that in articles.
Yes.
I'm coming, me and then I'm coming, and maybe Steven. Cause he's up working.
Ready, Ms. Smith? All right, we're back on the record, and I provided to council a consolidated and combined version of the charge, which I will mark a version as Courts Exhibit 5, tender that for the record, and that will be the copy that goes back with the jury. As you look at this and review it, let me know if you have any objections to it. And if I don't hear anything before we get to the charge of the jury, I'll assume there are no objections. I've also provided you all with a proposed verdict form, two-page verdict form. Any issues with that verdict form from the state, Ms. Russell?
No, Your Honor.
All right, Mr. Brown, do you see you have the verdict form in front of you?
I do. I see it. It's no issues, Your Honor.
Okay, then we'll be providing them with that. Ms. Russell, any reason we can't proceed to bring back the jury and begin with closing arguments? Mr. Brown?
No, Your Honor.
And Ms. Russell, is the state electing to use their opening closing?
We're just gonna close, Your Honor.
All right, so Mr. Brown, you'll be first up when the jury comes back.
Yes.
Deputy Scott. I'll just note for counsel as well, I'll have your time tracked. State will be red, defense will be blue.
If we can do.
Were we able to get anything tested on the laptop?
Yes, Your Honor, two of the videos play, one of the videos doesn't play. So the compilation plays, however, the video from 878 Norwood does not play. 1955 Moreland does play.
Have you been able to play those on your laptop with the same media player?
So I have, however, when they try, they can't. So I don't know, it might be a player that I have on my laptop that we're able to, that, they don't have.
All right, what about this? The exhibit that's the compilation, that does play?
Live for the jury.
All right, we'll take that back up. Thank you, Deputy Scott. Members of the jury, welcome back. Thank you for your patience. We are now ready to begin closing arguments. I'll remind you, as I said at the opening of this trial, that closing arguments are not evidence, and the state has the right to open and conclude closing arguments. So I'll turn it over to the state. Ms. Russell, is the state electing to open their closing arguments at this time?
Your Honor, the state will go last.
All right. So, Mr. Brown, whenever you're ready, sir.
Thank you, Your Honor. Good afternoon. I mentioned in my opening statement that the state has approved each of the crimes charged against Mr. Johnson beyond a reasonable doubt. That still applies. And it is our position that the state has not met their burden. State relies on two aspects of their case to prove that is Mr. Johnson who did the shooting. A video from 1955 Moreland Avenue and ballistics. Now, as far as the ballistics, you heard Mr. Tanner, their ballistic expert. The state has not proven that those cartridge casings were at the scene of the murder at the time of the murder. They could have been weeks before the murder, days before the murder. The state has to prove that beyond a reasonable doubt. They have not done it. So the ballistics doesn't help. So what's left is that video. We saw the video. The video does not show the two perpetrators' faces. They were concealing their faces. So what the state had Sergeant Barry testified to is that it has a still picture from the video, and they had a screenshot from a picture of my client at 878 Norwood, and basically relying on the clothing similarity. This burden is beyond a reasonable doubt because the states don't get any higher than they are right now. My client's charged with murder, 3 counts of felony murder, and some other very, very serious charges. So a screenshot and a video where you don't see the perpetrator's faces cannot be enough to meet that burden beyond a reasonable doubt. If you have a doubt in your mind, or a reasonable doubt in your mind, you have to acquit on the charge that you have a reasonable doubt about. If you have a reasonable doubt about all of the charges, you have to acquit Mr. Johnson on all of the charges. That's a high burden, and the state has not met it. So I ask you to find Mr. Johnson not guilty of all charges.
All right. Ms. Russell.
Yes, Your Honor. Thank you for your time. Told you about cold-blooded murder in the very beginning of this case. And you saw with your very own eyes, cold-blooded murder. You saw Jerry Carr gunned down at 1955 Moreland Avenue. He was 20 years old at the time. And the thing that I keep thinking about when it comes to Mr. Carr is that he went to the store for this. That's what he went to the store for. He went to the store first at 878 Norwood to get this. He ran into a snake. He ran into this defendant. And unfortunately, that snake bit. Ladies and gentlemen, $2, however much this costs. That. He wasn't doing anything wrong. You saw him. He was speaking to this defendant. This defendant hugged him. Hugged him. He showed him his phone. And according to this defendant, it was about real estate. And he then was bitten. He was shot 12 times. A bottle of mustard. I want to talk to you a little bit about your juror's duty, okay? And then I'm going to get into the facts a little bit more about with this case. A juror's duty, all right? What is that duty? And we kept asking you these questions during jury selection or voir dire, all right? Use your common sense. Common sense, okay? We ask you to be a fair and impartial juror, honestly seeking the truth. That's it. We want you to honestly seek the truth. You are not to seek doubt. That's one thing that you are not to seek out. You're to seek the truth, okay? So what are the things that you are not to consider? Well, you're not to consider, while you're deliberating, passion, public opinion. You're unhappy with the police in general. Public feeling, sentiment, sympathy for the defendant, whether or not you disagree with the law, because each one of you all stated that you all could listen to the law and put that law with the facts and evidence and render a verdict based on that. Conjecture, penalty or punishment, or even prejudice. That's not what you're to consider at all. But what you are to consider expert testimony, common sense, motive to lie, testimony of witnesses, credibility of witnesses, elements of the crime, defendant's actions, photos, and documents. That's what you are to consider. Okay? I show this because sometimes we do not know the entire story. That's in life. Right? Sometimes we're not going to know every single piece of the puzzle. But at the end of the day, we know what it is. And because there is a piece maybe missing, that does not mean that you cannot tell what this is. It's a $1 bill. You can tell that. There's pieces missing, you can tell that. And when I talk about pieces of the puzzle, I'm speaking about things like, well, why would Mr. Johnson do this? You may want to know why he did this. You may want to know why Mr. Ingram and him decided to do this after they had just spoken to this man. I can't tell you that, and I'm not going to claim that I can. We don't know. But that is not a reason. I'll get into reasonable doubt. But that is not a reason to doubt that Mr. Johnson and Mr. Ingram shot Mr. Carr 12 times, okay? So let's talk about the law, all right? The judge is going to give you the law, and I'm going to talk a little bit about it as well. But remember, law plus facts, you can render a verdict based on that. The defendant has the presumption of innocence. You're going to hear that, okay? When the state rested today, that presumption has gone. That's gone. He was guilty when the state rested. All of the evidence that we have put in, we have shown that this defendant is guilty beyond a reasonable doubt. Burden of proof. Our burden of proof, we know what our burden of proof is, and we understand, the state understands their burden of proof. It's beyond a reasonable doubt. We understand that that reasonable doubt is serious, okay? But one of the things that I want to make sure you understand that's the doubt of a fair-minded juror honestly seeking the truth. Okay, it's based on common sense and reason. And remember that it's based on common sense and reason. It's not beyond all doubt. It's not to a mathematical certainty. It's not a vague or arbitrary doubt. Okay, it's beyond a reasonable being that key word. And I'm going to get into a little bit more about that. And I'll give you a little story that illustrates beyond a reasonable doubt and next, direct and circumstantial evidence. You'll get a charge about direct and circumstantial evidence. Direct and circumstantial evidence are proof of facts and circumstances, or excuse me, direct is proof of facts and circumstances by direct evidence. So what does that mean? All right. Direct evidence is evidence that points immediately to the question at issue. Surveillance video. You saw with your eyes what happened, what took place. Okay? You saw with your eyes. Testimony from witnesses, what they heard, what they saw. Again, I said surveillance, ballistic evidence testimony, and the ME testimony. That was direct evidence from that particular witness. Circumstantial evidence is the proof of facts or circumstances by direct evidence from which you may infer other related or connected facts that are reasonable. There is no legal weight difference or no legal difference in the weight that you give direct or circumstantial evidence. I know sometimes people say, well, that circumstantial case doesn't matter. It's circumstantial. If it's proven, it's proven. Okay? Whether it be by circumstantial evidence or direct evidence. In this case, we do have direct and circumstantial evidence. There was not, and we are not claiming that there is a person who saw Mr. Johnson's face, right? The video does not show Mr. Johnson's face, and we have never alleged that. But through the other facts, through the other pieces of evidence, that circumstantial evidence, it shows that this person in the red, white, gray jacket was Mr. Johnson. Okay, so those pieces of other evidence prove it was Mr. Johnson. Okay, so I want to tell you a little story about this. Maybe we can remember it when you go back to the jury room and you're thinking about this case. So it's a January evening, and you're at your house and you are watching television, and it's a pretty nice day, but it's cold, it's January, and you put on your television, and the newsman comes on the television and says, ladies and gentlemen out there, it's going to snow tomorrow. And you say, what? It's going to snow, but it's such a nice day today. You know it's cold. It doesn't look like it was going to snow. Okay, so you said, all right, so I'm going to get snow ready. I'm going to get prepped for the snow. You let your faucets drip, but you start getting ready for the snow. You get your warm weather clothes out for the next day. You go to sleep that night. The next morning, you wake up and you say, oh, it's going to be snow out. Let me go downstairs, and you put on your robe and you head out the door. And the first thing you see when you step out the door is snow. There's snow on the sidewalk. There's snow on top of the houses. You're pretty much snowed in. You look to the left, you see snow on top of the houses there. You see snow down the street. You see a car ride by and it has snow on top of it. Okay? That car, you turned in from outside of your neighborhood. You look to the right. You see snow on top of that house as well. There's snow everywhere. So as you're going back into your house, you say, okay, the weatherman said no snow. But then your crazy neighbor to the left looks at you and says, hey, neighbor, those aliens came down and sprayed snow everywhere last night. And you say, okay, all right, okay, bye, neighbor. You look to your right, and your neighbor to the right says, dang, that movie director came down here and he set up all this snow in our neighborhood. And you say, okay. You go back inside of your house and you sit down and you're like, Aliens? Movie director? Huh? That just doesn't make sense. It doesn't make sense. You think, well, why doesn't that make sense? Well, it doesn't make sense because it's still cold out. It's the right weather, the time of year for snow. The newsman told you it was gonna snow. And though you did not see it directly, right? He told you it was gonna snow. And you know that maybe is it possible, is it plausible that aliens come down and spray snow everywhere? Maybe, right? But you don't believe in aliens. You know aliens aren't real. Is it possible you live in Atlanta, that movie set director made up, came and was gonna shoot a movie on your street? It's possible, right? But you think, I haven't gotten any notice of this. There was a car that came from the other side of the road or from outside the neighborhood that had snow on it, on top of it. It's possible, right? But it's not reasonable. That is reasonable doubt. That is not reasonable. The aliens coming down, it's not a reasonable story. It's not reasonable because of the direct and circumstantial evidence that show you that it snowed last night. Okay, so that's reasonable doubt, circumstantial evidence, and direct evidence. Intent. So intent does not mean that you necessarily intended the result, and you could intend the result of the shooting. When you point a gun at someone, shoot it, a projectile will come out and they may die, okay? So it is inferred from the natural and necessary consequences of the act. Point a gun at someone, shoot it, it's possible that they could die, okay? That's intent. Single witness, you'll hear about that. The testimony of a single witness, if believed, is sufficient to establish a fact. Generally, there's no legal requirement of corroboration of a witness, provided you find the evidence to be sufficient. If you believe one witness, right, that is enough to find the defendant guilty. You can believe just one, right? You can find the defendant guilty based on, I believe that witness. You're gonna find it guilty. Okay? Party to a crime. And I want to talk a little bit about this because party to a crime concerned itself with not only Mr. Johnson, but also Mr. Ingram. Okay? Every person concerned in the commission of a crime is a party to it and may be charged with and convicted of the commission of that crime. Whatever one does, they all do. So let's say, and we believe that this is Mr. Johnson. If you believe, yep, I know that was Mr. Ingram. I know that was Mr. Ingram. You know that was Mr. Johnson. But you say, well, maybe, I'm not, they were together before, but I know that was Mr. Ingram that shot. You can find this defendant guilty based on party to a crime. Okay? So party to a crime directly commits the crime, okay? Intentionally helps in the commission of the crime, or intentionally encourages another to commit the crime. Okay? So Mr. Ingram commits the crime, Mr. Johnson does as well. Right? Ingram and Johnson acted as a team. Right? Their mission was to kill Jerry Carr, and they succeeded in their mission. They acted as a team. You're going to get a charge about identity, and this is a lot to go over, okay? But the state has proven their case, has proven identity. Because that seems to be the defense here, that it wasn't me, right? And there's multiple ways that we prove identity, all right? Use your common sense and reason. So what are the crimes charged? count one is murder. All right, when a person unlawfully and with malice aforethought causes the death of a human being. Okay, malice can be expressed or implied. All right, we don't have to choose one. It can be expressed or implied. It's what you feel malice, what happened here. So the deliberate intention to kill, and I'll be quite honest with you, I believe this was expressed malice. Mr. Johnson and Mr. Ingram waited for Mr. Carr to come out of that building and shoot him. This was expressed. They wanted him dead. And not only that, they shot him 12 times. Sorry, I'll go back. Malice, implied malice, no significant provocation, and all the circumstances show an abandoned and malignant heart. Okay? And so like, all right, so what is that, right? It's not necessarily an ill will or hatred for somebody. You don't have to find, or you don't have to, think that, well, maybe he hated him. I think he possibly did, because you don't shoot somebody 12 times, right? However, that's not necessarily malice, but it's the unlawful intention to kill without excuse or without obligation. Okay? Premeditation is not required. That's going to be some of the law that's given to you. I believe it was a premeditated crime, or premeditated murder, excuse me. No particular length of time is required for malice to be generated in the mind of a person. It can be formed in a moment, but it was premeditated, right? They got into the car after Mr. Carr walked away from 878 Norwood and got into his car and followed him. So from the time they got to their car, followed him to 1955 Moreland, got out of their car, put hoods on their head, and walked from one place to the other. That's premeditation. Okay? You'll get a charge that no proof of motive is required to prove murder. I don't have to prove the motive. Like a snake. Snake is a snake. Okay? So when we're talking about murder, again, I ask each and every one of you during voir dire this question. Will you be able to listen to the law that the judge gives you, the facts and evidence, and render a verdict? And we believe that you would be, and that you can do that on murder, that you will be able to render a verdict of guilty. So what do we have here? And how I learned in law school, we take the law that the judge is going to give you, and you break it down, right? When a person, who is that person? Jamon Johnson, unlawfully, so he's not justified in any way, with malice aforethought, okay? Express malice, that malice aforethought, remember we talked about that? What is that? Expressed or even implied. He shot Jerry Carr 12 times, implied, shot while Jerry Carr not looking and hiding out, lying in wait, abandoned and malignant heart, right? Causes the death of a human being. Jerry Carr died from gunshot wounds. So one of the things that you do is you just break down the law. The judge is going to give you the law. He's going to read it to you. He's going to give you the law. Go to murder and you plug in the facts with the law. Jamon Johnson is guilty of murder. Okay? You look at your indictment here, murder, and you'll see that the state has laid out how Jamon Johnson committed that murder. Okay? Next is felony murder. That's counts 2, 4, and 5. Some of the counts are going to be skipped because some of them are for Mr. Ingram. But then also some of them are Jamon Johnson and Mr. together. Okay. So felony murder. When a homicide is committed during the commission of a felony, must be a connection between the homicide and the felony being committed. Malice is not required. Okay. I don't have to prove the intent to kill. All right, so count 2, 4, and 5. When a homicide is committed, right, Jerry Carr died during the commission of a felony, aggravated assault and firearm by a convicted felon. And we'll go to aggravated assault and firearm by a convicted felon, right? And we'll talk about those, because if you find that Mr. Johnson committed aggravated assault and you find that he also had a firearm by a convicted felon, there's 2 of these, Jerry Carr died while he was in the act of that, then you can find that, that Jamon Johnson is guilty of felony murder. Okay. So let's talk about aggravated assault, because that's a predicate of one of the felony murder counts, but it's also its own separate count. Look at the indictment. You can see what he's been charged with. Aggravated assault with a deadly weapon. When a person assaults another. To prove assault, the state does not have to prove that the other person was actually injured. However, the state must prove that the defendant attempted to cause a violent injury to that person with a deadly weapon. You'll get language that a firearm is a deadly weapon. All right? Here, defendant pointed a gun, shot the gun at Jerry Carr. What happens when you shoot and point a gun at somebody, or point and shoot a gun at somebody? They could die, all right? With a deadly weapon. A firearm is a deadly weapon. You'll get that as well. So the law plus the facts, put those together, you will be able to find this defendant guilty of that. Possession of a firearm during commission of a felony, okay? When a person has a firearm on or within arm's reach of his person during the commission of a felony. So here are the felonies that he's charged with. Did he have a firearm during the murder, during the felony murder or the aggravated assault? If you find that the defendant had a firearm, which we know he did because he shot, you can see him shoot. During the murder, felony murder, aggravated assault, you may find him guilty of this charge as well. Counts 10 and 11, last ones. And 10 and 11 are a little bit different, but they have some of the similar facts. Possess a firearm after having been convicted of a felony, okay? All right. So what we have to prove is that Mr. Johnson committed a felony. Excuse me. Possessed a firearm. But also he was convicted of a felony. All right. Here's the stipulation right here, where he was convicted of a felony. It's right here. He signed it as well. Mr. Johnson was convicted of a felony previously, and he possessed a firearm this time. You can find him guilty of count 10. Count 11 adds on one more one more element, and that is prior felony involves possession of a firearm. Okay, so his prior felony involved the possession of a firearm. It's right here. So this one is, go here. Possess a firearm, defendant had a firearm or a gun, right? We saw him with that gun in the surveillance video. After having been convicted of a felony, counts 11 and 12, defendant stipulated. That's right. That's state's exhibit 1. Okay. So the defense's argument, I mean, his face is not shown. So what are they saying? Because your face is not shown, you can get away with murder? You can get away with any crime if you just cover up? That's the defense? That cannot happen here. That's not how this works. Maybe the defendant had a twin, right? And had on the same exact thing, right? That he had on. Maybe, right? That means also that Jacob Ingram had a twin. Remember going back to reasonable doubt and whether it's reasonable. Does that story make sense? No, that does not make sense. The defendant, the Superman switched clothes with somebody really quick. And he also not only switched clothes with somebody really quick, but the gun that he used on the prior occasion, he switched guns. He gave him that gun, he switched his clothes, and he did it really quick. I mean, in a matter of minutes. From the time Detective Barry, and we'll talk about this, testified from the time, it takes 4 minutes from the time you go from 878 Norwood to 1955 Norwood, approximately. The shooting happened around 10:05 or 10:06, and we'll go into that a little bit more. It couldn't happen. Same gun used in the shooting before magically reappeared with a different person. So the same gun he had shot previously magically reappeared with a different person that also happened to have on the same clothes as he did at 878 Norwood. That does not make sense. Okay? Use your common sense. And then also one of the questions asked of Mark Tanner at the very end here. So the shell casings fired on the scene were there before Mr. Carr's body was shot up. Now, that is, I mean, it's clear as day that two people, Mr. Johnson and Mr. Ingram, shot Mr. Carr right there on scene. So the story about that they just were there beforehand, that doesn't make sense. And the ballistics evidence, the evidence from the medical examiner, says otherwise. So I go back to face not shown, and murder is not a spectator sport. People don't just commit murders in broad daylight and show their face. It's not a spectator sport. You cover up. That's what happens. So remember that. I'll go through a couple of the witnesses. Mr. Uden, store closes at 10 p.m. and this is for timing purposes, right? He recognized himself in the still shots and he stated that he was scared. He testified he feared for his life because these guys hang out at the store. He didn't want to be hurt. He didn't want to be here because they hang out at that store. Go through some of the clips. Jacob Ingram, Jamon Johnson turned around where you can see his gray, it's unique enough, gray sweatshirt on one side, white on the other side. Jacob Ingram. Again, Jamon Johnson, Jacob Ingram here. And then this might be a video. Oh no. You have the victim speaking to the both of them. I think this is the video. And at some point, and this is in 4 speed, Jamon Johnson get out, hug him, dap him up, and they speak for minutes, at least 10 to 11 minutes. Now this is sped up. And if you want to watch the entire thing, not sped up, have at it. But it looks to be a friendly conversation. And at some point in time during this, and I'll keep going, but at some point in time during this whole encounter, you'll see Mr. Carr take out his phone and show Mr. Ingram. They'll be over here in this area. You'll see him show him something on his phone. It's probably his real estate license, like he said. He had no reason to hurt this man. None. That's Garshanda. He's the owner of 1955 Moreland. Spoke to the victim, nice guy. He had a BMW. Kept looking out the window when he bought his Mustang. Okay. Thought he heard fireworks and saw 2 guys running away. He did not see their face and it was a holiday. Just wanted to sum up his testimony. But he got that video in 1955 Moreland. So one of the things that I thought was interesting is Sergeant Barry said that she was able to see the cars arriving. I wanted to point out those times for you, just in case you wanted to see, to go back and look at that, okay? So the victim's car turns onto Issa Drive at Issa Drive Southeast. At that time, 22:04:25. And at 22:04:38, the defendant's bluish gray car quickly follows but parks on the back street. So let's see. This is Issa Drive. Some point, black BMW comes along here and parks. And at some point, the defendant's vehicle parks along the street back up in here. So let's see what time I said it was. 22:04:25 is when you see the victim's car. 22:04:38 is when you see the defendant's car. 24:25, the victim's car turning. And it'll link back up to another video. 22:04:38. Look closely. That car, bluish, grayish looking car, slowly parked. It's back up in here. Sorry. All right. 22:04:45. Again, well, 22:04:32. First, you'll see the victim's car seen on Issa Drive from another angle. But then 22:04:45, the victim's pulls into the parking space. You can see the headlights next to that red truck. Okay. So just went by right here. And at some point, you'll see in this area, car pull up and stop. You saw headlights pull up right here. Ultimately, you'll see that the victim gets out of his vehicle and he'll be speaking to that gentleman in the blue. Okay. So then you see the defendants arriving. They get out of their car after they parked it. And you'll see circled each one of them coming in this area. And that is Jamon Johnson. He has on that lighter color sweatshirt. A few moments later, you'll see Jacob Ingram. It's at 22:05:45. Military time. See them arrive from this angle. At 22:06:03. Jamon arrives. A few seconds later, following behind Mr. Ingram. Lying in wait, peeking out. And you talk about malice on the phone at that. Not a care in the world about Mr. Carr. So we know Jamon Johnson's the primary shooter because we see it, right? Oh my God. Wow, watch that. The car is gonna walk out and is ambushed. Mr. Ingram's magazine falls out and they both take off. Okay, so identity, it's why we're here because he's saying it isn't him. Okay. Surveillance videos and ballistics. It's not just a screenshot, but it's surveillance, the entire, all of the surveillance video. It's all of the ballistic evidence, everything. It's not just one piece of it, okay? That is the circumstantial part. You have to link it back together. It's a puzzle piece. That puzzle piece tells an entire picture. So here are some witnesses, right, to the puzzle piece. Why do we bring Sharon Latners? Well, she gets in timing. At 10:08, 8 minutes after 878 Norwood, 10:08, these are being dispatched. It's quick. It's quick. It's not a long time period from the time that Mr. Carr and Mr. Johnson speak, right? Crime scene tech Benson now works for Cobb County Medical Examiner. Well, he collected those shell casings in the magazine. Got to get those in, got to get that piece of the puzzle to show what happened with Mark Tanner and how he was able to test those. Again, same thing with Antoinette Green, crime scene tech Green. She was able to get that Smith & Wesson firearm in that backpack along with Jacob Ingram's medicine. So it wasn't a random backpack at the random house. It was Jacob Ingram's backpack along with his medicine, right? Officer Gilbert, defendant told him he shot. Okay, need to get that piece of the puzzle in. He spoke to the defendant. The defendant said he shot at 878 Norwood in October 2020. Investigator Smallwood, again, he gets in the shell case. And the defendant also told him that he shot. Dr. Sullivan, the death was by gunshot wounds. I gotta prove the death. I gotta prove that Jerry Carr is dead, right? That's a part of the elements, okay? So these are all pieces to the puzzle. And when you put all those pieces together along with everything else, he's guilty. Sergeant Savannah Berry got in the surveillance videos, reviewed all of the surveillance videos. She was able to backtrack the victim's steps, again, to the previous store, had that very distinct hoodie, and she talked about that. Okay. Here it is. Defendant. I mean, all the way down to the keychain. all the way to the keychain. I mean, if you believe that what the defense is saying, that it wasn't him, that it was somebody else, that means he had to copy him all the way down to his keychain, which is, it just doesn't make sense, right? That's not reasonable. And here's the back. It's kind of blurry right there because of the pixelation, but the biggest thing is the two-tone hoodies. Sergeant Barry said this was not a crime of opportunity, it was planned. Okay, this was a planned attack. All right, this wasn't a robbery. This is something that they did because they planned it, right? That goes to the malice murder. So one of the things that we have to do when you have to do is to ensure that the statement that was given, his constitutional rights are read. Jitmon Johnson's constitutional rights are read. And hopefully you all can all hear. So.
Listen, I'm Detective Barry. Now, you was picked up by our fugitive unit. They said that you wanted to talk, is that correct?
I'm trying to see what's going on.
Okay, I understand that, and it is gonna take a conversation for you to get all of that information, but I do have to read your rights, okay? Just wanna make sure that you understand this before I go out and print all this stuff and have this conversation with you, okay? So let me just read this, you can respond accordingly, and we'll just go from there, all right? What's your first name? Jitmon Johnson, yeah? All right. You do have the right to remain silent. Anything you say will be used in court as evidence against you. You are entitled to have a lawyer now and have him or her present now or at any time during questioning. If you cannot afford a lawyer, one will be appointed for you without cost, and he or she may be present at all times during your questioning. You can decide at any time to exercise these rights and not answer any questions or make any statements. Do you understand these rights? Okay. Do you wish to talk to me at this time without your lawyer?
I just want to know what's going on.
I understand. That's going to take a conversation. Do you want to have this conversation and speak with me without your lawyer now?
I guess I got to talk to you to see what's going on because I'm lost here.
I understand. So what I'm looking for is like a yes or no. And I hear what you're saying, but just for documented purposes, yes or no. You want to speak with me now?
Yeah, I'll talk to you. What's
okay.
going on? What's going on?
Let me grab some stuff. It's not much longer. I've been here for a little bit. It's already.
Hey, look, did they send some pans up here by me, man?
Who?
At the house they picked me up on.
All right. So you'll get a charge about constitutional rights and whether or not they were read, right? And what was read, and whether or not the defendant waived those rights and freely spoke. Okay. Clearly he freely spoke. Or clearly he waived those rights. They were read. All right. So just want to make sure that you all had seen that and understood what was going on, specifically with that particular charge. So defendant's interview, particular, important points. He stated that he was the one in the picture on 878 Norwood. Detective Barry confirmed he was speaking about 878 Norwood.
Ingram's head right here.
Okay.
Who's this right here?
That's me.
This is you. Now.
Okay. He admitted, he said that's me at 878 Norwood. 8 minutes before police were dispatched. Excuse me. At that location, 8 minutes before police were dispatched. Defendant admits to speaking with the victim on the day of the incident. Sergeant Barry states, you and the victim spoke for about 11 minutes. He admits to that.
in your phone.
His name is not saved in my phone.
I assume because you said he was gonna help you out and get you on some path, y'all didn't exchange numbers or anything?
No, I didn't exchange with him because he supposed to be coming back the next day and talk more business. He pulled out his phone and showed me his certificate of where he just graduated from real estate.
When did he show you that?
He showed me that day. If I'm not mistaken, that day.
This day? This is y'all right here. You shaking hands with him. Cool as shit, right? Was it that day?
Defendant admits he was at 878 Norwood. Again, Sergeant Barry shows him 6 photographs and he says that he shows him this 6-pack of photographs, which is Stacey's 75, and he says, this is him here. He says this wasn't him here.
I wasn't doing nothing. I don't know nothing. I said this wasn't me, just trying to get to the next question. But yeah, that's me.
But yeah, that's me. Okay. So let's get into the ballistics. Not too much longer, all right? That also identify Mr. Johnson. And I'm just going to use the same chart that we've used before, right? This indicates that this gun fired these 2. And the remainder here, besides 1, because one of them was not able to be tested, were all fired from the same gun. That same gun being a Glock 9mm, okay? These shell casings here match 11, I believe 18 match firearm. Remember, we have party to a crime. If you believe that Jacob Ingram fired this gun that came from Jacob Ingram's bag, then you are able to find that this defendant also committed the crime, okay? And then the last one, these 9 shell casings, and there were 2 other ones, I believe, that aren't photographed here, match these shell casings from the October 2020 shooting, where you can see Mr. Johnson firing his firearm and Smallwood, Sergeant Smallwood, excuse me, they collected the shell casings from this area and that they matched one another. That identifies Jamon Johnson as a shooter. That is enough. 9 of those shell casings, and I said this before, right, that Jamon Johnson was the primary shooter. 9 of those shell casings were from a Glock 9mm. He shot the most. His intent was to kill Mr. Carr. And then lastly, Officer Darlene Scott. She got on the stand, said he was hiding in the attic. Hiding in the attic when the police came. Why are you hiding in the attic? The consciousness of guilt. Police come, let me try not to get caught. Remember his buddy, Jacob Ingram, had already been arrested. He was hiding in the attic from the police. Jerry Carr, right, the son, brother, he did not deserve to be gunned down like that. Not at all. And he had so much life to live at only 20 years old. He went to the store day before Thanksgiving for mustard. At 1955 Moreland Avenue, his life was taken. His life was taken by Mr. Jamon Johnson and Jacob Ingram. Ladies and gentlemen, this is not the Wild Wild West, right? This is not how, if there was some sort of beef, there was anything going on between them, there was anything that they believe that Mr. Carr did to them, anything, then this is not the way we handle that. Not in Fulton County. And you, ladies and gentlemen of the jury, are residents of the Fulton County. And when I submit the case to you all and the judge reads you the law, you are the ones that will decide that this defendant committed these crimes. Enough is enough, not in Fulton County. Not anymore. Jerry Carr did not deserve this. I'm asking you to hold this defendant accountable for his actions. Find him guilty of each and every count of this indictment. Each and every count. Thank you.
Members of the jury, at this point, it is my obligation to charge you on the law that applies to this case. That process takes about 20 minutes. Is there anybody that needs a break before I begin that? Then let's do that. Whenever y'all are ready, we can resume. So I'll have you step in the back. And we have a question. And this is from juror number 2 for the record. Let's keep it down just for a moment. Let's hold in place. Juror number 2, do you have something you wanted to ask? Okay, yeah, we're just letting everyone go back and we'll come back out when you're ready.
All rise for the jury.
All right, we'll be in recess and off the record until they indicate to us. Otherwise, I imagine that's not going to be longer than about 5 minutes. So please don't go far.
Wow. I have to. Thank you. Is it charged?
Yeah.
It's a fast charger.
Yeah.
It's full? Oh, was it? I was trying to record too. Cause I ain't want them like, why should I represent? Oh, yeah. was just trying to get contact with her. She was at fault a little bit. I put it on her name.
You did? Okay, you did. I'll go.
What's his name?
That's your case.
You know, Deputy Scott, it's took me out this morning. Oh, bro, what you eating now? What you eating now?
I don't know business, man, when I'm in.
It is. Hey, so what you agree with? She, you tell her that she gonna come to us. Yeah. She read that out, but that's probably the second. So the judge will
I appreciate you.
Beg your mom's.
Okay, so when I bring them out, I'll tell you.
Is it for, it's for him?
Yeah, for
Oh, okay.
Court come to order, remain seated.
It's okay. You know?
Oh,
I didn't have to.
That is bugging me.
Get up, and I was gonna let you just come on.
That light is killing me.
Oh, no. Yeah, that's what I.
Yes, let's go ahead and bring him out. Yeah, I went from the back to here, and I don't know if they fixed it or what they, I don't know what they're doing. I'm just gonna do what I can do.
No, I got it. I know. Charging me and other things.
Did you want to tell me? She bad, I told you. Yeah, the gun, yeah, but the jury didn't get to see that big, thick packet that details all your charges are.
Sister. That'd be.
All right, Deputy Scott, why don't you check in on them? We can just see if they're ready for us.
I'm looking at I look at things differently from a juror because I got knowledge and stuff. So to me, I would say no, but to these 12 people who just want to say.
They're ready? Okay, give me 1 minute. Let's go back on the record, and I want to just address one thing with both parties before we bring the jury back in and I charge them. which is that I overheard an audible interjection during the state's closing, and Deputy Scott confirmed with me that that was Mr. Johnson's mother. And this had been someone who had interrupted us previously before at a break. And apparently she made a comment to the effect of commenting on the evidence. And this being the second audible interruption we've had, I think at this point, to prevent further interruptions and any kind of interjections, which would impede the flow of this trial, that I'm going to be instructing Deputy Scott not to allow her into this courtroom throughout the charge of this jury, and if we receive any verdict. After that point, anyone can rejoin us, and anyone, of course, can watch live on our YouTube feed of anything that's going on in here. And so, Mr. Brown, if you want to provide her with that or any other member of her family, but I just don't trust her not to have some other kind of audible disturbance at this point. All right. So if there's anything else you want to be heard on that point, otherwise, she and she alone would not be allowed in until that's changed. All right. If there's nothing else, then let's bring back in the jury.
No, the judge has to tell all of this law. That read the whole thing. That's going to take about 20, 30 minutes.
All rise for the jury.
Excuse me.
Thank you, Deputy Scott. Members of the jury, you are considering the case of the state of Georgia versus Jamone Johnson. The grand jury has indicted the defendant with the offenses of murder, felony murder, 3 counts, aggravated assault, possession of a firearm during the commission of a felony, and possession of a firearm by a convicted felon, 2 counts. You will be provided of a copy of the indictment and a copy of these instructions during your deliberations. The defendant has entered a plea of not guilty to this indictment. The indictment and the plea form the issue that you are to decide. Neither the indictment nor the plea of not guilty should be considered as evidence. The defendant is presumed to be innocent until proven guilty. The defendant enters upon the trial of the case with a presumption of innocence in his favor. This presumption remains with the defendant until it is overcome by the state with evidence that is sufficient to convince you beyond a reasonable doubt that the defendant is guilty of the offense charged. No person shall be convicted of any crime unless and until each element of the crime is proven beyond a reasonable doubt. The burden of proof rests upon the state to prove every material allegation of the indictment and every essential element of the crime charged beyond a reasonable doubt. There is no burden of proof upon the defendant whatsoever, and the burden never shifts to the defendant to introduce evidence or to prove innocence. However, the state is not required to prove the guilt of the accused beyond all doubt or to a mathematical certainty. A reasonable doubt means just what it says. A reasonable doubt is a doubt of a fair-minded, impartial juror honestly seeking the truth. A reasonable doubt is a doubt based upon common sense and reason. It does not mean a vague or arbitrary doubt, but is a doubt for which a reason can be given, arising from a consideration of the evidence, a lack of evidence, or a conflict in the evidence. After giving consideration to all of the facts and circumstances of this case, if your minds are wavering, unsettled, or unsatisfied, then that is a doubt of the law, and you must acquit the defendant. But if that doubt does not exist in your minds as to the guilt of the accused, then you would be authorized to convict the defendant. If the state fails to prove the defendant's guilt beyond a reasonable doubt, it would be your duty to acquit the defendant. Members of the jury, it is my duty and responsibility to determine the law that applies to this case and to instruct you on that law. You are bound by these instructions. It is your responsibility to determine the facts of the case from all of the evidence presented. Then you must apply the law that I give you in the charge to the facts as you find them to be. Your oath requires that you will decide this case based upon the evidence. Evidence is the means by which any fact that is put in issue is established or disproved. Evidence includes all of the testimony of the witnesses and any exhibits admitted during the trial. Evidence does not include the indictment, the plea of not guilty, opening or closing remarks of the attorneys, or questions asked by the attorneys. Direct evidence is that which may be seen or heard or otherwise directly sensed, such as by smell or taste or touch. It may be brought into court in the form of exhibits or the testimony of direct witnesses to such matters. It is evidence that points immediately to the issue in question. When direct evidence by inference points to an obvious, likely, or reasonable conclusion, even though that conclusion was not directly seen, heard, smelled, tasted, or touched, that is said to be circumstantial or indirect evidence. Circumstantial evidence is the proof of facts or circumstances by direct evidence from which you may infer other related or connected facts that are reasonable and justified in light of your experience. It is evidence that only tends to establish a conclusion in question by its consistency with such conclusion or elimination of other conclusions. Sometimes circumstantial evidence may point to more than one conclusion. To authorize a conviction on circumstantial evidence, the proved facts must not only be consistent with the theory of guilt, but must also exclude every other reasonable theory other than the guilt of the accused. The law does not require a higher or greater degree of certainty on the part of the jury to return a verdict based upon circumstantial evidence than upon direct evidence. Whether dependent upon direct evidence or circumstantial evidence or both, the true test is whether there is sufficient evidence or whether the evidence is sufficiently convincing to satisfy you beyond a reasonable doubt. If not, you must acquit. If so, you may convict. There is no rule that either circumstantial or direct evidence is stronger than the other if conflicting. The comparative weight of circumstantial evidence and direct evidence on any given issue is a question of fact for the jury to decide. Testimony has been given in this case by certain witnesses who are termed experts. Expert witnesses are those who, because of their training and experience, possess knowledge in a particular field that is not common knowledge or known to the average citizen. The law permits expert witnesses to give their opinions based upon that training and experience. You are not required to accept the testimony of any witnesses, expert or otherwise. Testimony of an expert, like that of all witnesses, is to be given only such weight and credit as you think it is properly entitled to receive. The testimony of a single witness, if believed, is sufficient to establish a fact. Generally, there is no legal requirement of corroboration of a witness, provided you find the evidence to be sufficient. The defendant does not have to present any evidence, nor testify. If the defendant chooses not to testify, you may not consider that in any way in making your decision. A statement that the defendant allegedly made while in custody has been offered for your consideration. Before you may consider this as evidence for any purpose, you must determine whether the defendant's statement was voluntary, and if the statement was given in custody, whether the defendant was properly advised of his constitutional rights. To be voluntary, a statement must be freely and willingly given and without coercion, duress, threats, use of violence, fear of injury, or any suggestions or promises of leniency or reward. A statement induced by the slightest hope of benefit or the remotest fear of injury is not voluntary. To be voluntary, a statement must be the product of a free will and not under compulsion or any necessity imposed by others. You may consider the legality, duration, and conditions of detention as factors relevant to the question of whether or not a statement was freely and voluntarily made. However, under the law, in order for a statement to be excluded because of an illegal detention, it must be shown that the statement was, in fact, induced by such illegal detention. The burden of proof is upon the state to establish that the statement was voluntary, that is, freely and willingly made. If you do not find that the statement was voluntary, you may not consider it for any purpose. If you find that the statement was made in custody and as a result of police questioning, you must also determine whether the defendant was advised of his constitutional rights and whether the defendant clearly understood and knowingly gave up such rights. The constitutional rights that law enforcement officers must explain and that the defendant must understand and voluntarily give up before any custodial statement is taken by law enforcement are as follows. 1, the defendant had the right to remain silent. 2, if the defendant chose not to remain silent, anything he said could be used as evidence against the defendant in court. 3, the defendant had a right to consult a lawyer before any questioning and to have the lawyer present with him at all times during any questions. And 4, if the defendant did not have money for a lawyer would have been provided for him to represent him before any questioning and to be present with him during any questioning. The burden of proof is upon the state to establish that the warnings of all rights mentioned were given, that they were understood and knowingly given up by the defendant. If you find, as mentioned above, that the defendant's statement was voluntary and that all of the warnings as to the defendant's constitutional rights were given, and that the defendant did not understand the meaning of what was said and knowingly gave up such rights, then you may consider it as evidence. If so, then you must apply the general rules for testing the believability of witnesses and decide what weight, if any, you will give to all or any part of such evidence. If you fail to find the defendant was properly informed of these rights and that he understood and gave up those rights, you must disregard the statement entirely and give it no consideration in reaching your verdict. Sometimes evidence is admitted for a limited purpose or for some counts and not others. Such evidence may be considered by the jury for the sole issue or purpose and only for the counts for which the evidence is limited and not for any other purpose. Identity is a question of fact for you to determine. Your determination of identity is dependent upon the credibility of the witness or witnesses offered for that purpose. You should consider all of the factors previously charged to you regarding credibility of witnesses. Some, but not all of the factors you may consider in assessing reliability of identification are: 1, the opportunity of the witness to view the alleged perpetrator at the time of the alleged incident. 2, the witness's degree of attention toward the alleged perpetrator at the time of the alleged incident. 3, the possibility of mistaken identification or identity. 4, whether the witness's identification may have been influenced by factors other than the view that the witness claimed to have. 5, whether the witness or on any prior occasion did not identify the defendant in this case as the alleged perpetrator. And 6, the length of time between the crime and the out-of-court identification. It is for you to say whether under the evidence in this case, the testimony of the witnesses and the facts and circumstances of the case sufficiently identify this defendant beyond a reasonable doubt as the perpetrator of the alleged crime or that the defendant was a party to it. It is not necessary that the defendant show that another person committed the alleged offense. If you do not believe that the defendant has been sufficiently identified as the person who committed the alleged crime or was a party to it, or if you have any reasonable doubt about such, then it would be your duty to acquit the defendant. The burden of proof rests upon the state to prove beyond a reasonable doubt the identity of this defendant as the person who committed the crime alleged in this bill of indictment. This defendant is charged with a crime against the laws of this state. A crime is a violation of a statute of this state in which there is a joint operation of an act and intention. Intent is an essential element of any crime and must be proved by the state beyond a reasonable doubt. Intent may be shown in many ways, provided you, the jury, believe that it existed from the proven facts before you. It may be inferred from the proven circumstances or by acts and conduct, or it may be in your discretion inferred when it is the natural and necessary consequence of the act. Whether or not you draw such an inference is a matter solely within your discretion. This defendant will not be presumed to have acted with criminal intent, but you may find such intention, or the absence of it, upon a consideration of words, conduct, demeanor, motive, and other circumstances connected with the act for which the accused is being prosecuted. Every person is presumed to be of sound mind and discretion, but this presumption may be rebutted. You may infer, if you wish to do so, that 1, the acts of a person of sound mind and discretion are the product of that person's will, and 2, a person of sound mind and discretion intends the natural and probable consequences of those acts. Whether or not you make such inference or inferences is a matter solely within the discretion of the jury. Every party to a crime may be charged with and convicted of commission of the crime. A person is a party to a crime only if that person, A, directly commits the crime, B, intentionally helps in the commission of the crime, or C, intentionally advises, encourages, hires, counsels, or procures another to commit the crime. A jury is not authorized to find a person who is merely present at the scene of the commission of a crime at the time of its perpetration guilty of consent in and concurrence in the commission of the crime, unless the evidence shows, beyond a reasonable doubt, that such person committed the alleged crime, helped in the actual perpetration of the crime, or participated in the criminal endeavor. A jury is not authorized to find a person who is merely associated with other persons involved in the commission of a crime guilty of consent in or concurrence in the commission of the crime, unless the evidence shows, beyond a reasonable doubt, that such person helped in the actual perpetration of the crime or participated in the criminal endeavor. For malice murder, the state must prove that the defendant, 1, caused the death of another person, 2, unlawfully, and 3, with malice aforethought. The killing must have been done with malice to be murder. Malice, as the term is used here, is not necessarily ill will or hatred. Rather, it is the unlawful intent to kill. You may find malice when the circumstances show that the defendant acted with the deliberate intention to unlawfully take the life of another person. You may also find malice when there does not appear to be significant provocation, and all the circumstances of the killing show an abandoned and malignant heart. The state does not have to prove premeditation to prove murder. If a killing is done with malice, it is murder regardless of how briefly the malicious intent existed. No specific length of time is required for malice to arise in the defendant's mind. Malice may be formed in a moment, and instantly a fatal wound may be inflicted. If malice was in the defendant's mind at the time of the act or the killing, and moved the defendant to do it, that is enough for the killing to be murder. The state does not have to prove motive to prove murder. Any evidence of motive has been admitted for your use in determining the defendant's state of mind at the time of the killing. For felony murder, the state must prove that the defendant, 1, caused the death of another person, 2, by committing a felony. The state does not have to show that the defendant acted with malice to prove felony murder. Aggravated assault with a deadly weapon and possession of a firearm by a convicted felon are felonies, which I'll define for you shortly. You may find the defendant guilty of felony murder if you believe that he caused the death of another person by committing the felony of aggravated assault with a deadly weapon and or possession of a firearm by a convicted felon, regardless of whether he intended the death to occur. There must be some causal connection between the felony and the death. Felony murder is not established simply because the death occurred at the same time as or shortly after the felony was attempted or committed. The felony must have directly caused the death or played a substantial and necessary part in causing the death, regardless of when the death ultimately occurred. For aggravated assault, the state must prove that the defendant, 1, assaulted another person, 2, with a deadly weapon. To prove assault, the state does not have to prove that the other person was actually injured. However, the state must prove that the defendant attempted to cause a violent injury to the person or committed an act that placed the person in reasonable apprehension or fear of immediately receiving a violent injury. A firearm, when used in the way a firearm is ordinarily used, is a deadly weapon. For possession of a firearm during the commission of a felony, the state must prove that the defendant, 1, had a firearm, 2, on his person or within arm's reach of his person, and 3, while committing a felony, which is a crime against or involving another person. Murder, felony murder, and aggravated assault with a deadly weapon are felonies. The term firearm includes any handgun. For possession of a firearm by a convicted felon, as alleged in count 10, the state must prove that the defendant, 1, possessed a firearm, 2, after having been convicted of a felony. For possession of a firearm by a convicted felon, as alleged in count 11, the state must prove that the defendant, 1, possessed a firearm, 2, after having been convicted of a felony involving the possession of a firearm. For purposes of this offense, a firearm includes any handgun. The law provides that criminal actions shall be tried and indicted in the county in which the crime was committed, and a prosecution in any case in which it cannot be determined in what county the crime was committed, venue is proper and may be proved in any county in which the evidence shows beyond a reasonable doubt that it might have been committed. Venue, that is, the crime was committed in Fulton County, is a jurisdictional fact that must be proved by the state beyond a reasonable doubt as to each crime charged in the indictment, just as any element of the offenses. Venue must be proved by direct or circumstantial evidence, or both. By no ruling or comment that the court has made during the progress of the trial, has the court intended to express any opinion upon the facts of this case, upon the credibility of the witnesses, upon the evidence, or upon the guilt or innocence of the defendant. Your verdict should be a true verdict, based upon your opinion of the evidence according to the laws given you in this charge. You are not to show favor or sympathy to one party or the other. It is your duty to consider the facts objectively, without favor, affection, or sympathy to either party. In deciding this case, you should not be influenced by sympathy or prejudice because of race, creed, color, religion, national origin, sexual preference, local or remote residence, economic status, for or against either party. You are only concerned with whether the defendant is guilty or not guilty. You are not to concern yourselves with punishment. One of your first duties in the jury room will be to choose one of you to be the foreperson. The foreperson will manage your deliberations and will sign the verdict to which all 12 of you freely and voluntarily agree. You should start your deliberations with an open mind, talk with each other, and consider each other's views. Each of you must decide this case for yourself, but you should do so only after discussing and considering the case with your fellow jurors. Do not hesitate to change an opinion if you are convinced that it is wrong. However, you should never give up an honest opinion to be congenial or to reach a verdict solely because of the opinions of the other jurors. During your deliberations, you must not communicate with anyone other than your fellow jurors about this case. You are also not permitted to conduct any research about this case, including persons, places, or legal concepts mentioned during the trial. These rules apply not only to in-person communication, but also to communication or research using cell phones, text messaging, websites, blogs, or social media of any kind. Whatever your verdict is, it must be unanimous, that is, agreed to by all. The verdict must be in writing and signed by one of your members as foreperson, dated and returned to be published in open court. We have compiled a verdict form, which we will include with the exhibits when we send those back to you for you to complete and to aid you in your deliberations. At this point, is there any objection to the charge as given by the state? Mr. Brown? Members of the jury, I want to clarify one aspect I said, I mentioned concerning voluntariness of a statements, and I want to recharge you on this, but by recharging you, I want to emphasize that there's no greater weight placed on this charge than any of the other charges. I think I just misspoke when I conveyed this to you. And so the charge, again, as I mentioned, concerns voluntariness and constitutional rights. And I charge you as follows. If you find, as mentioned above, that the defendant's statement was voluntary and that all of the warnings as to the defendant's constitutional rights were given, that the defendant did understand the meaning of what was said and knowingly gave up such rights, then you may consider it as evidence. If so, then you must apply the general rules for testing the believability of witnesses and decide what weight, if any, you will give to all or any part of such evidence. If you fail to find the defendant was properly informed of these rights and that he understood and gave up those rights, you must disregard the statement entirely and give it no consideration in reaching your verdict. All right, you may now retire to the jury room, but please do not begin your deliberations until you receive the indictment, the verdict form, and the evidence that we are allowed to share with you and provide you in the jury room. With the exception of jurors number 29 and 32, if you could stay behind with us. The rest of you may retire to the jury room.
After the jury.
All right, jurors 29 and 32, as you may have heard in the charge or just generally know, a jury generally consists of 12 people. And there are 2 extra seats in this box for our alternates, and you were previously determined to be our alternates. As I mentioned before, trials are unscripted things, and a lot of times we lose jurors throughout the week, and that's why we need to have alternates. And we still may need you. Oftentimes, we don't know how long deliberations are going to last, and sometimes something comes up where we need to sub in an alternate. So what I want to do at this point is I'll excuse you for the day. You can go home, resume your life, whatever else you had planned, but not quite yet. Don't run for the door just yet. I need to tell you a few things. We're going to call you and let you know when your service is concluded. And what I mean by that is if we need to bring you back, we're going to let you know to sub you in as an alternate. Or we're going to tell you that the case is resolved and that you're excused from your service. Until you get that call from us, you're going to remain under those 2 instructions I tell you every single day, which is not to discuss the case with anyone or anywhere, and not to do any research about the case. So if I don't see you again and you're not asked to come back, I want to thank you so much for your patience this week and for your service as jurors. All right. Thank you all. All right. Did we have, for the record, a list of, again, a final list of what will be kept back from the jurors in terms of exhibit numbers?
Your Honor, we didn't make a list of that, but you can just go through it. I know, number 1 will be kept back. That's the number 1 call. Number 63, that's body camera, October 26, 2020. Number 76, Mr. Johnson's interview with Detective Berry. the demonstratives, Your Honor, which are going to be 64A, 74A, I believe that's it.
All right. Are there any additional exhibits, Mr. Brown, that you believe should be held back, or do you agree with that?
I agree with that, Your Honor.
All right. So then the last point then is what we should do about this laptop, if anything. What we heard before we broke was that we could get the compilation video to play on it, but not necessarily the other two exhibits. So my thought is,
Actually,
well, we got an update.
sorry, the 1955 Moreland Avenue video will play, the compilation video will play, and the only one that won't play is 878 Norwood video. And I'm sorry, Your Honor, I can refer to them via the exhibit numbers. Exhibit number 71 will play. Exhibit number 71A will play.
And do you have any idea why that is?
I do not know.
Okay. 71 and 71A will play, but which one will not?
65 will not.
All right. So our options here, and I'll just leave it to the parties, is we can just leave it at that. Let them ask to come out and watch whatever video they want, like we would normally do, or we can send them back with the two that will play and leave it there. I'm up for suggestions. Mr. Brown, do you have any preference?
I don't have a preference, Your Honor.
I don't have a preference, Judge.
All right. Well, then if there's no objection, I would say we send it. I would delete the video that does not play off the flash drive, which would be 65. And I'm going to ask Deputy Scott to take the charging cable and that laptop back to the jury and to tell them that Exhibit 71 and 71A is there and they're able to review it if they want. But he's going to also tell them that they are not to use this laptop for any other purpose other than to review 71, 71A if they would like to.
The evidence already went back?
And to take that back with all the other evidence.
So that's compilation. So these are the only two that.
Oh, sorry.
Yeah, so the only thing that's in this folder is. So. Yeah. So just write it form. So just the that I showed it to him already.
Did you want to see this,
Right.
Mr. Brown?
I'm sorry.
Did you want to see the evidence that was going back?
No, I know what it is.
Okay, and then the stuff that's held back is right.
Sounds good. Is that pistol going back?
Yeah, it's locked.
Okay.
You have it locked on it.
Okay.
Cause I already showed it to him.
All right. So just for purposes of the record, I think Mr. Brown has had an opportunity to review the laptop and the contents of the hard drive. And so we will send that back to the jury along with other exhibits. And I'll note the time as approximately 3 o'clock. And we'll be in recess until we get any word from the jury. Thank you all.
Yeah, that's all.
What you got? Yeah, I know.
Come back. Come back. I'll come back.
Oh, probably right.
Yeah. I know.
So I'll put it right here.
What?
What?
Oh, that's interesting. That's really interesting. I heard it, they were really good.
So
They offer
they let him see the flash drive, so I make
Yes.
sure everything matches.
Yes, sir. Here you go.
I don't know. Oh, that actually is. Okay.
Oh, now we wait. The worst part. Oh, no. You wanna wait? You gonna stay or I wanna stay? No, whatever you.
Well, hi there.
Hour.
Who are you after?
One of the jurors that went over there. You ran.
Yeah, Adam was like, what? I was like, what?
Adam's on the phone.
Is that one you're sweating?
Oh, Brown or Adam?
Yeah.
Brown soldier or Adam?
Huh?
Brown soldier or Adam?
Alan.
Yeah, I was on the phone with him.
Yeah, shot the shine.
Who?
No Raymond.
Oh, yeah. You know, I don't go by the first name.
Start talking to Greg.
You got a face in that. It's possible, right?
Sure.
About to go see you. I can get fixed. Juries come back.
All right, we're back on the record. Just a few minutes ago, I was informed by Deputy Scott that the jurors had reached a verdict. And before we bring the jurors back in to deliver that verdict, I just want to say a word to any members of the gallery, which is that I understand that criminal trials can be quite emotional things. However, I would ask you to each search yourselves and decide if you were to hear a verdict, whichever way it would go, if that is something that you would be unable to prevent from saying something, from making any kind of a audible or disruption, then I would ask you to step out at this point before we have to escort you out, as we cannot have any kind of outbursts or disruptions of any kind. So with that, if we could bring in our jury.
If it is, I'll follow him for a new trial today. Okay. All rise for the jury. They let me. That's fine. Okay.
Just waiting for a word from you, Deputy Scott. All accounted for?
All accounted for.
All right, thank you, everyone. Please be seated. Members of the jury, I've been informed by Deputy Scott that you have been able to reach a verdict. And so I would ask the foreperson who's been selected among you to just rise and identify themselves for me by their jury number. All right. Now, juror 28, were you able to reach a verdict? Was it unanimous? Has this verdict form been filled in, signed, and dated by you? All right. If you could hand that to Deputy Scott so that I may take a look. All right, ma'am. What I would ask you to do at this point is to publish the verdict by reading it out loud.
Ready to count?
Yes, ma'am, from the top.
As to count number 1, murder, we, the jury, find the defendant guilty. As to count 2, felony murder, we, the jury, find the defendant guilty. As to count 4, felony murder, we, the jury, find the defendant guilty. As to count 5, felony murder, we, the jury, find the defendant guilty. As to count 6, aggravated assault, we, the jury, find the defendant guilty. As to count 8, possession of a firearm during commission of a felony, we, the jury, find the defendant guilty. As to count 10, possession of a firearm by a convicted felon, we, the jury, find the defendant guilty. As to count 11, possession of a firearm by a convicted felon, we, the jury, find the defendant guilty.
Ma'am, if you could hand that verdict form back to Deputy Scott. And you can have a seat. Counsel, if anyone would like to inspect the verdict form, it is available for you here. Ms. Russell, is there any reason on behalf of the state we cannot excuse this jury?
No, Your Honor.
Mr. Brown?
No, Your Honor.
All right. In that case, members of the jury, we've reached the point where I can thank you for your service. The requirements I'd asked of you not to talk with anyone or to discuss the case, those are now lifted. You do not have to discuss the case with anyone, but if you want to, you can. And in just a moment, I'm going to excuse you so you can collect your devices. And if you need excuse letters, we can also arrange for those for you. And what I also like to do is just take a moment to go into the back and thank you for the time you spent on this case. And if you have any questions, I'd like to answer those as well. I also try to give the counsel the opportunity to come speak with you if you want to. Sometimes it helps attorneys to know how they did, if there are things that played a role in your deliberations, just to kind of draw back the curtain of what happens in a jury room. So you certainly don't have to stick around for that. You can leave immediately if you'd like to. It is with the thanks of this court for your service that you can be dismissed. Thank you.
All rise for the jury.
I would have a better idea as far as grounds for an appeal. Certainly have a right to appeal, absolutely. Yeah, you can.
All right. Mr. Brown, is there any reason we should not proceed to sentencing today?
There's no reason, Your Honor.
All right. I want to instruct the deputies, if there's anyone now that wanted to re-enter the courtroom, just the individual that we'd excluded, she's welcome to come back in. I'm going to take a recess here so that I can talk to the jurors and thank them for the service. Did either counsel want to be able to address them and speak to them as well?
Yes, Your Honor.
No, Your Honor.
Understood. We'll be in recess for about 15 to 20 minutes.
Right. They're right here.
Oh.
They're right here. Let me just get.
Yeah, I actually.
I tell you all the time. Let me say, if you jump out on him, I gotta help. I got you.
Okay, I appreciate you.
Move it. One coming back. One coming back.
So let's make sure, this is 123. Is that fair?
Oh. Relaxing? No. This is. I seen it look good. It's just your vote gonna change. Hey.
How you doing? I see you on special occasions.
It's gotta be different, stay away.
Ma'am. Ma'am. You want to?
Okay.
Is that our couldn't help you yesterday? We wanted to talk about that. Good job. Couldn't have done it without. I'm saying, you get more videos, so make you walk.
You gonna go back?
They let us, he said go now?
Well, I think she gotta wait till the judge finishes.
Yeah, I'll wait till the judge.
What's up, man?
Gotta, you know, they got questions they don't wanna ask us.
Supporter.
I was looking at you.
Congratulations, thank you so much. Thank you for all your hard work, both of you. Thank you for all your hard work. You were an amazing second chair. You can second chair me anytime. Anytime.
I remember that.
Thank you, Quentin. You were amazing as well. Thank you, thank you, thank you for all your help. How are you?
Boy, you don't ever put me as cosmetic as no more here. And everyone.
Mm-hmm.
But it don't make it rare you.
What'd you say? Do I have court somewhere? I'm sure I got court somewhere. But you know what, Cardi is in court too. So she's in trouble.
Yeah.
This is all the evidence.
Oh, no, well, yeah, and then I got the laptop, just gotta get it back there.
Yeah, look at the case. I saw a snippet of the surveillance video.
It's good.
He literally just put out gun and just shoot the guy. Get it across the wall. That he's home.
Oh, really?
I already ordered his certified, so they should be coming in hopefully by today.
Maria, you sent me on all my cases.
I would love to. You are straight to the point.
Especially that Michigan, scholar. You be perfect with that case. When you was looking at.
Oh,
Yeah. So it just like, I got a jury. I was like, how many kids they got? But we got
Good.
it. Doesn't matter.
Right. You know, you think about that stuff like that, you be asking stuff.
I'm just, what's your hobbies?
Right. Let's move through this thing, girl.
Can you send me the layout of the wrong series, please? So I can close that case all out, because tomorrow I'm gonna start closing. Okay. Yeah, I copied it, my file, and I
printed it, so when I get back downstairs, it's awesome.
Thank you. You're the best. Thank you for all your hard work. I appreciate it. Thank you. Congratulations, or thank you. I'm not sorry. Congratulations, you're done. Right.
You know, we want.
Yeah. Right.
So.
Do what you can do when. I mean, you got responsibility, so you can only do something. I get it. Thank you. It was a pleasure working with you. So yeah, you got Billy Wells.
Nice meeting you.
I've worked with this.
Yeah.
Sorry.
Oh, yeah.
Mr. Brian?
He said he didn't want to. He said he didn't want to.
Talk to the jury?
Yeah.
Nice, I passed that. God knows. So I don't Zoom.
I saw you out. Hi.
Hey, how are you?
I'm well, thank you. I haven't seen you in a while.
Well,
Since
yeah,
the last
well,
trial we did with Mr. Lee.
yeah. Oh, yeah. Fines, right? The fines case,
I
yeah.
said, get out now.
I think so.
Yeah.
Was it a not guilty? I think it was a not guilty.
When I tried, are you talking about Jerome Lee?
Sure.
Attorney?
I don't remember which one it is.
I hadn't had a not guilty in a while,
Get out.
knock on wood, so,
That's good.
you know. Oh, yeah, okay, I was in here with, yeah, okay, so
I think you were filling in or something.
yeah, but he got a guilty on it.
I don't remember. Okay. Oh, what do you want jurors in it? I can use anything. I can call this talk. They get more time. Yeah.
I think so. I don't remember. They froze it, but yes, when I take my name out, they pull it out.
Oh. What she said.
I have to log in.
And then, but we have nothing done.
Give my email address. We could bring up Mr. Johnson.
It seemed like it would eat it up.
I know. But there is that one.
All right, let's go back on the record. Having received the verdict and dismissed the jury, believe it's been represented by counsel that we're ready to proceed to sentencing. And so beginning with the state, do you have any, first I'd like to hear your position on what you believe the sentence should be, as well as what merges and what vacates, and what the state is recommending. And then if you have any evidence in aggravation or argument as to why that should be the sentence.
Thank you, Your Honor. Your Honor, the state is going to be asking for a sentence of life without the possibility of parole. We believe as to count one, that should be the sentence. It's to count two, 4, and 5, that should vacate as a operation of law. Count 6, aggravated assault, should merge. Count 8, possession of a firearm during the commission of a felony. We are asking for a period of 5 years consecutive to the life without the possibility of parole. Count 10, we believe, will ultimately merge with into count 11, Your Honor. For count 11, possession of a firearm by a convicted felon, we are asking 15 years consecutive to count 8. So that's a total of life without the possibility of parole plus 20 years.
Why would 8 not merge into 11?
So
what element of count 11 or count 8 is not included within count 11?
I'm sorry, I couldn't hear you.
What element of count 8 is not already included in count 11?
I believe the possession during the commission of a felony portion of it, Your Honor.
Well, let's read the language of the indictment. Firearm during the commission of a felony against and involving a person of another, said accused having been convicted of aggravated assault. And I'd refer the state to Atkinson 301, Georgia 518.
Atkinson 301, Georgia 500.
518.
And Georgia. Firearm does not merge into conviction. No. Rather than merge into possession of firearm into the felony more amounts, the trial court should have instead merged the felon and possession count into the relating to these. Merge the possession of firearms during the commission of a crime count into the use of a firearm by convicted felon. I mean, well, according to this, Your Honor, I believe, and I stand corrected. It clearly states that the possession during the commission not relating to use of a firearm.
No need to rush. Take your time. Take a look at it.
Okay. All right. Well, based on this, Your Honor, we believe that we stand corrected and that it does merge into count 11, 133. So, Your Honor, that would be as to count 8, that would merge. Count 10 would also merge, and then count 11, we're asking for 15 years consecutive to count 1. So that's life without the possibility of parole plus 15 years. I'm sorry.
Argument, evidence, and aggravation.
I'm sorry, Your
like
Honor. I also do have, and you didn't mention, Your Honor, I do have a victim impact statement that I would like to the court to hear. Would you like to hear that first, or would you like to hear
whatever the state prefers?
Okay. All right. And ma'am, when you come up here, can you just please state your full name for the record?
My name is Alicia Price.
And Ms. Price, is there anything that you want me to know about what you think the appropriate sentence is in this case, and how are you connected to this case?
Well, I'm connected. I'm Jerry's godmother. As far as the sentence in this case, I feel it's appropriate. It saddens me because on both sides, it's still a lose-lose situation. Nobody wins here. As far as Jerry, practically raised him with my kids. He and my daughter are like 4 months apart, same age, graduated together, grew up together with all my kids. He didn't deserve this, as was stated, and it's true. His mom died last August, waiting for justice for her son. And I'm standing here in the gap for them. The night it happened, he went to the store to buy mustard. Normally, anything he needed or anything he had a question about, he would come to me. I live across the street from them. I was hoping and, just trying to figure out why that night he didn't come to me for mustard. Since I haven't been able to even use mustard. I like mustard, Thanksgivings haven't been the same. You heard he had just completed his real estate exam, and he was excited about that because he started the process of preparing for it while he was still in high school. He was taking care of his mom. She had cancer. So he was her main caregiver. But once he was taken away, the neighborhood had to step in. He would cut the grass for elderly neighbors. Just constantly trying to progress himself to not become a victim of these mean streets.
Thank you for being here today, Ms. Price.
Your Honor, I'm going to tender into evidence State's Exhibit. I'll continue at 123, which is a conviction from October 5th, 2012. Your Honor, where Mr. Johnson pled guilty to a negotiated plea here in Fulton County. He pled guilty to aggravated assault with a deadly weapon, two counts of aggravated assault with a deadly weapon, false imprisonment, three counts of false imprisonment, and also, Your Honor, I believe that was all he pled guilty to on this case. Your Honor, I was just making sure I got it right, but according to the accusation, the one that he pled guilty to, this was for 3 different people, specifically with the aggravated assault. The state alleged that in those cases, those victims were struck on the head with a handgun. They were then tied with rope, burned with cigarettes, and then also beat with the accused hands and fists, and shooting at the feet of those victims. Your Honor, that's case number 12 SC 106855. And that State's Exhibit 123. I'll tender into evidence on that one. Your Honor,
Can you tell me more about that? What was the sentence that you received?
Your Honor, the sentence on that one was a 5-year sentence that was upon 2 years service. The remaining 3 was going to be on probation.
So that wasn't a commuted to time served type thing. It was remitted to the Department of Corrections?
Yes, Your Honor.
And do you have any other info, other than the allegations, about what that case was about or what was going on?
I don't have any other info. I see there were a number of individuals that were also charged in this crime. Other than that, that's all I have for that particular case.
All right, and that is a certified copy that you've shown to opposing counsel?
Yes, he's seen this.
All right, any objection to admission of exhibit 121?
No objection.
123.
123, rather.
No objection.
123 is admitted for the record.
Your Honor, I also have a certified copy of a conviction out of Fulton County. It was filed in July 17th, 2015. It's 14 SC 130077. It is for a violation of Georgia Controlled Substance Act. It's possession of cocaine with intent to distribute. This defendant pled guilty. He received a sentence of 10 years to serve 1 year, commuted to time served, balance 9 years on probation. So at the time of this incident, he still was on probation. Your Honor, as far as the,
Is that also something you're tendering for the record?
I am tendering that, Your Honor. That's State's Exhibit 124.
124,
The
certified
certified
copy.
copy.
Any objections, Mr. Brown?
No objection, Your Honor.
It is admitted.
Your Honor, as far as the reason we are asking for this life without parole, life without the possibility of parole sentence, Your Honor, the egregiousness of these acts, the fact that Mr. Johnson, he laid in wait for Mr. Carr. Seemingly there was no reason, no justification, and with any murder, I shouldn't say with any murder, but with the murders that come before this court, we don't believe that there's excuse or justification, but in this one, there just wasn't. The defense was identity. Your Honor, we believe that obviously identity was proven in this matter, but the fact that Mr. Carr was riddled with bullets 12 times over his body, after he had just gotten a hug from this particular defendant, it's unconscionable, really. So I would ask that you sentence the defendant as recommended by the state.
All right, thank you, Ms. Russell. Mr. Brown.
Your Honor, on behalf of my client, I ask that you sentence my client to life with the possibility of parole. I ask that the court shows mercy, and I can understand that the court may feel that Mr. Johnson had not shown any mercy. I'm just asking the court to show a grace that the court may not feel that Mr. Johnson showed. His family has been here throughout the trial. His mother, I believe his mother would like to speak on the issue, if she can come up.
Oh my God, Jesus. Judge, you wanna please don't send my son away for the rest of your life. You got children. Yeah, one of his daughters sitting over there. He have two more other kids that really need their father. And Jamal is good. He's a good guy. He's a God. Jamal is good. You don't deserve no life in jail. Have mercy on my son. Judge McAfee. Your Honor.
All right, thank you, ma'am.
Thank you. Do you think his daughter wants to talk?
Yes. Happening.
And Mr. Brown, just for the purposes of the record, could we have her full name for the record?
Oh, I'm sorry. Please state your full name for the record.
Joshua Johnson.
Tonjua. UA.
All I gotta say is,
You state your name first.
my name is Heavenly Johnson, and
How are you related to Mr. Johnson?
this is my dad.
Okay.
And I'm just here to say I love him because you can't say he does not deserve what he's getting because murder is murder. Somebody lost their life. So I can't blame it on the DA that's going against him. I'm just here to say I love you, Dad.
Would you like for him to have life with the possibility of parole? So that
What is parole?
parole is after a certain amount of time, in this case 30 years, that there's a body, a group, an organization that can determine if he could be released or not. Would you like that?
I would like for him to take life with the possibility of parole.
Thank you.
Thank you for being here, Ms. Johnson.
You are. Please state your name for the record.
My name is Sharika Bailey.
How are you related to Mr. Johnson?
I'm his baby mother. Okay. And I have 2 kids by him.
What would you?
Jamani, I don't, to me personally, I just don't feel like it's fair, you know, because like I go through stuff like that the same as well, you know, people picking at you, you know, and it's like when you caught in the law, I feel like it's not, they're not there until something really happens to someone. So I feel for him as well because, you know, like when you get picked at, you call and you ask for help, you know, when it's there to help you and, you know, someone shooting at you, it's, I'm emotional and I'm sorry, y'all, but it's, I don't even know what really to say because I go through things like that too. When people are picking at you, picking, you know, shooting at you and stuff, trying to take things from you too as well. I just don't feel like it's fair for him to get life.
Would you like
I
for him to
don't.
have the possibility of being released one day?
Yes, sir. Yes,
Okay.
sir.
All right. Thank you. So again, Your Honor, I'm just asking for the court to show mercy upon my client and sentence him to life with the possibility of parole. Thank you.
Is there anything else, Mr. Brown, you want to present?
No, Your Honor.
Okay. All right. So as represented by the state, there is really only a small window of options for sentencing in this case. There's a mandatory minimum of life imprisonment. The question really just becomes whether we believe Mr. Johnson, after trial in this case, should be eligible for parole at some day. The evidence presented in this case is that, as I understand it, when this crime occurs, some time has passed. But even then, Mr. Johnson was not a young man. He's someone in his 30s. And this is not the first time that he's decided to have a gun and to use it. And even leading up to today, I just still have not heard any acceptance of responsibility for his role and what happened to this whatsoever. And I think, as the state points out, every case is a little different. But this one is a classic case of a premeditated malice murder. I think that we saw that this was something that was planned, and we saw that Mr. Johnson had every opportunity to reconsider and to choose life. But he did not. And I think that was also evidenced by the jury's swift verdict in this case. So it certainly doesn't give me any pleasure, but I think I do feel compelled to accept the state's recommendation. I believe, as Mr. Brown points out, that mercy should be dispensed when it's justified, when it's earned, but I just don't see any reason for that or justification in this case, especially when we see what he showed to Mr. Carr, who also should have had the opportunity to have a daughter. Speaking on his half today. So after considering the evidence in aggravation and mitigation, I'll impose the following sentence. On count 1, the sentence would be life without the possibility of parole. Counts 2, 3, 4, and 5 vacate by operation of law. Count 6 merges into count 1. Count 8 merges with count 11. Count 10 merges with count 11. And count 11 would be 15 years to serve consecutive to count 1. Mr. Johnson, I have a few things that I need to advise you of, which is that you have the right to seek post-judgment relief from your conviction of these crimes by either making a motion for new trial in this court or by filing an appeal to a higher appellate court. If you want to file a motion for new trial or an appeal, you need to file that motion or notice of appeal with the clerk of Superior Court of this county within 30 days. You may want to discuss this more fully with your attorney. If a motion for new trial is made and the court denies it, you would then have 30 days following the denial to file with the clerk of court your notice of appeal. You have a right to an attorney to represent you on a motion for new trial and the first level of direct appellate review. And if you cannot hire an attorney, the court will provide you an attorney and a transcript of your trial at no cost. These all being felony convictions, you have a period of 4 years from this date that your sentence in this court is entered and becomes final to file a habeas corpus petition. Is there anything else to address on behalf of the state?
No, Your Honor.
Anything else? Mr. Brown?
No, Your Honor.
Will be adjourned.
Jesus, Charles. No.
Thank you, sir.
Oh, where'd that come from?
I'm sorry.
It was in the laptop.
Yes, it is ours. Yes. Here you go. Thank you so much.
Oh, how does she get his clothes?
Wait. They want to wait, we can bring them back up.
Oh,
Let them know if they want to wait or not.
You wanna wait?
Wait, how long? Wait, I can't tell you that. We gotta set them all the way down. We get them undressed and stuff.
Oh, yes, we got the same suit. No, but we have the same suit. We got the same suit.
Are you a attorney? Oh, you're not?
Oh, yeah. Thank you. Thank you.
I don't think Taste practice now.
Where would they be at?
I don't think they're come, I don't think they're practicing.
Yeah.
Why?
If they wanna come back and get his clothes, what would they pick them up at?
They built it.
They will have them.
They built it. This is-
But what happened?
You'll have them tomorrow? Coming tomorrow?
I can go.
Okay.
Yeah.
Yeah, come to this point. Are you guys in here on Friday?
Probably. I'm gonna be quite honest with you, probably.
Trying to be fucking.
Yes, you are.
All right.
Now she got to look.
Yeah, it's okay. It's like tomorrow.
Yes, right?
Before check off.
Good job.
Okay, we're done.